Milord, with sincere apology, Milord, item 27 and 28. Some difficulties today, Milord. Can it be taken up day after tomorrow? Any other date, Your Lordship, please.
No, accommodation is no problem, but the problem happens when you say that not today, but on that day.
But as Your Lordship
is-
pleases, I leave it, Your
We'll
Lordship.
adjourn it for 2 weeks then.
No, 1 week.
Item 27 and 28. On the request of Mr. A. Samuel and counsel appearing for the petitioner, made with the consent of the other side. Hearing of these matters stand adjourned for 1 week.
I'm obliged.
My lord, I'm praying for listing this writ petition, my lord, for tomorrow, my lord. Yesterday I withdrew this writ petition, my lord. I have filed it again, my lord, for praying for quorum today.
May I please, Your Lordship? My Lord, I beg to mention for listing of a matter for order column. Can it be, my Lord, after day after tomorrow?
2nd week of June.
Because, my Lord, I have to take steps, my Lord, in this case, but in the meantime, one of the respondent, my Lord, was posted to another, he was transferred to another place. So steps were taken to be not within 3 days as per the last order, my Lord. But I cannot take this step because the address I have to correct, my Lord. So that will be
Next week.
2 matters.
Next
Obliged.
Item number 5, my lord, I beg to withdraw this matter. I have informed Mr. B. Gogoi and Mr. B. Chaudhary for PWD.
Item 5, Mr. P. Bharadwaj, learned counsel for the writ petitioner submits that he has instructions from his client to withdraw this writ petition. Since the prayer is made with the consent of the opposite party, same stands allowed. Writ petition stands disposed of on withdrawal. Any interim order here?
No.
Yes.
May I please, Your Lordship? Lordship, I pray for listing of a miscellaneous case which pertains to restoration of a disposed of pension matter.
Next week.
May it please, my lord. I beg to mention item number 23, my lord. I have taken other such concern, my lord. Can we pass over for the day, my lord? 23, my lord.
On the council, on the prayer of learned counsel for the petitioner, this matter stands, hearing of this matter stands adjourned
After 2 weeks, my lord, maybe.
for 2 weeks.
May I please, Your Lordship, I beg to mention for listing a matter for admission. The matter is about the conversion from armed branch constable to unarmed branch constable.
3rd week of June.
May I please, Your Lordship? Lordship, I beg to mention for listing of a case, Lordship, in Muson Estates.
What is the case about?
Lordship, contempt case.
Huh?
Contempt case.
You wait. When did you file it?
Lordship, actually, Lordship, it was listed, but Lordship, I did not appear, Lordship. So, Lordship,
You write an application to the register. He will do
Lordship.
it.
Lordship. Another payer, Lordship, for withdrawal, Lordship.
May it please, Your Lordship. Lordship, I beg to mention item 2014 item for listing, Lordship, for orders. WPC number 3368 of 2014. Lordship, the matter pertains to a disciplinary authority was inflicted penalty of dismissal of service, Lordship.
31st May. Yes.
My lord, I'm praying for listing of a motion, my lord, on Friday.
What is the matter?
My lord, it's a matter, my lord, where ICU technicians are sought to be appointed, but they did not possess the degree on the last date of submission of the application.
May I please, Your Lordship? I'm praying for listing of a contempt case. It may come up in the month of June, any date,
In the month of,
June. Any date.
you fix the date.
May I please, Your Lordship?
Yes.
One of the matter with the compassion appointment, my lord. And here, my lord, DLC, my lord, my matter was twice placed before the DLC. In the first occasion, DLC rejected on the ground of delay. Then I approached before this honorable court, and this honorable court makes certain observation, my lord, rejected to place the DLC. That DLC, my lord, while rejected my claim, my lord, absolutely ignoring the observation made by this honorable court. I like to draw your lordship first attention at what order passed by this honorable court. Page 36, my lord. Dated 19/12/2018, my lord. Whole facts of the even petitioner mother also applied, my lord. She died, my lord, on cancer, my lord. This all recorded. Finally, observation at page 30, para 12. and 13.
So where is the order of the DLC?
Yes, my lord. Page 45 and operative portion page 46, my lord. 10, number 10, my lord, 46. The divisional child control officer consults Imdadul Haq, my lord. And bottom, my lord. Since the application not received in time, in the meantime, application spent force with the principal hence rejected. Same ground on delay, my lord.
5/9/2015.
So what is wrong with this?
My lord, let it be, this honorable court is specifically directed in paragraph 12, my lord, the delay not be a ground for rejection of my application, my
No,
lord.
this is not because of delay.
No, let it be, I made application after, earlier I made application, my lord, then in view of this honorable court order, I again fresh application I preferred, my lord, that.
No, no, Mr. Laskar, this is not rejected on the ground of delay. The court only said, do not reject his application on the ground of delay.
Late application, it is, it's a delay, my lord, late. So initially I applied, my lord. Here I have annexed that application, my lord. My first application.
So
my lord.
now the appointment on compassionate ground scheme has been withdrawn. That has been done since 2017. Right. So can there be a direction to appoint on compassionate ground?
At this is my only humble prayer, my lord. Though, my lord, the first round, my lord, rejected delay.
No,
Second
no,
is
you
a-
first address the court on this point.
My lord,
Today, can a direction be issued to appoint him on compassionate?
I'm not claiming for appointment. My prayer at this stage, my lord, let them to decide, fresh, place my matter before the JLC, my lord, considering this.
But then we'll say that, but they need not grant his application.
No, my lord, let them first decide. Only at this stage, by this is only
No,
sufficient.
Mr. You have to address the court on this. How can a writ be issued now to appoint him since the scheme has been withdrawn in 2017? So today in 2023, how can we direct them to appoint you? You address the court, convince, I'll pass an order.
My lord, if the lordship is correct, my lord, then impugn order passed on 9/7/19 and this honorable court order on 19/18, my lord. After rejection, all these developments has taken place. So my humble state, I lost my father and mother, I am having two minor sisters. My lord. Only lost, my lord.
See, that purpose. This has become a never-ending business. You tell us what is the law. If that is correct, we'll accept and apply it uniformly to all cases.
Lordship, absolutely,
Randomly.
Lordship, correct. Lordship, I understood, my lord.
Randomly, we can't do it. One case this, one case that. This is creating a chaos.
Lordship, I am appearing for soil conservation department, my lord, and my lord, department have given my lord the list of my brief, my lord. In this particular case, I have not received the brief, my lord. So today I have received the brief on from my other council, my lord. So I need time, my lord.
Lordship, what did I will think about it.
You want to do it before some other bench?
No, this
That will
bench,
be a better idea for you.
no, my lord, this bench, I'm not, this.
Well, unless I am convinced on the legal issue, no order will be passed by this court, regardless of anything.
The question Lordship has put, I'm not prepared, my lord, it is Lordship.
No,
correct.
that's all right.
Yes,
You may need time to prepare. There is no difficulty.
yes, my lord.
And I am also telling you, if you can convince the court, I am open to passing an order.
Yes, my lord.
But you can't say that forget the law, give me relief.
No, I can. No.
That will not
No,
work
no,
in this.
I will not, my lord.
In any case,
Yes,
in
my
any, whoever is the counsel, whoever is the petitioner, whoever is the issue, whatever the
My
issue,
lord,
orders will only be passed in accordance with law.
my lord.
And the councils have full liberty. I am ready to hear you for a
Yes.
whole day.
Yes,
You are address argument and prove and establish that this is a case where a mandamus can still be issued. I will.
your lordship, give some time, my
How
lord.
much time?
1 week or 2 weeks, my lord.
You put in your effort. Heard Mr. P.K. Dekar, learned counsel appearing for the petitioner. Also heard Ms. R.S. Deori, learned standing counsel, Soil Conservation Department, Assam, as well as Mr. D. Bora, learned government advocate, Assam, appearing for the official respondents. On the request of Mr. Dekar, this matter stands adjourned for 2 weeks, so as to enable him to examine the legal issues and address argument. Registered to list this case again after 2 weeks on a non-miscellaneous day on a miscellaneous day in the motion column. This writ was
Yes.
filed in 2029.
My lord, extra copy may be sir.
In the meantime, extra copies will be furnished to the learned departmental counsel.
Lordship, in this case, Advocate General was appearing, Lordship. Today, Lordship, due to some work, he is out of station. Lordship may kindly take it
No,
up
but what
tomorrow.
is the matter? If we don't want to hear the Advocate General, then we'll continue with the case.
I leave it to you.
Because these things will go on happening. The court's business must go on. What is the issue?
Issue is that, my lord, the one advertisement was published to post of the port gate service, my lord, under the whole department, under the government of Assam, my lord. One advertisement was published on 25/3/2022. Lordship will find that advertisement at page 18, annexure 1. As per this advertisement, my lord, the maximum qualification is HSSLC higher secondary class 12 pass, and minimum qualification is the class 8, my lord. Our grievance is that, my lord, as per this advertisement, my lord, who has acquired the higher education than the higher secondary, they are not eligible to apply for the post, my lord. During the exam, after the examination, we have find that so many persons who have acquired the higher qualification, they have been selected, my lord.
Who are the persons? Where are the names?
My lord, we have given some name in this list, my lord. In this petition, my lord. Lordship will find at page.
You have to make them party.
No, my lord, because they are not appointed till then.
Then I will dismiss your petition. You cannot make allegation against someone and not make him party. That a trained lawyer will never do.
No, my lord, actually what happened, my lord, till date, my lord, they were not appointed. And one thing, my lord, why.
You are making allegation, then you wait when they will be appointed.
One thing, my lord. Another point, my lord. Another point is that, my lord, till there no result sheet has been published, my lord. No merit list has been published, my lord. Without the making.
Then you give up that point, then
Yes.
we'll record it.
Yes, without the making of the result sheet, my lord, they are going to make the appointment, my lord. This is not
Where is the statement?
paragraph 5, my lord.
Yes, let us read it.
Page 9. Duly appeared in an interview, and the petitioner stated that while the petitioners were expecting favorable consideration of their candidature by the respondent authorities, the respondent number 3 announced the declaration of the result of the selection process for filling up the post of grade 4. However, the respondent authority did not publish any result sheet or final merit list of the selected candidate for making appointment. The respondents have made a provision to verify the result of the selection selection through online by two web portal, that is Assam portal and Seva portal, wherein a respective candidate can check only his result by inserting the roll number, and candidates were shown as qualified or not qualified, my lord.
So that is, they have done, online publication is there.
Nothing has been published.
Huh?
Nothing has been published.
There is nothing
Published.
online, it is not available.
Online only individual result. My lord, kindly see what kind of result has been published, my lord. That is at page 39, annex 4.
No, Mr. Borua, be very clear, otherwise it is not going to work out. You are a candidate, you have a right to know your result. You want to know the result of others also.
My lord, this is because in the advertisement, there is another terms and condition number 3, my lord. Without the result sheet, it cannot be ascertained, my lord, who has been selected, who has not been selected.
No, that is none of your business. You are only entitled to know whether you have been selected or not. Why you want to know who else has been selected?
Because, my lord, so many person higher qualified person has been selected, my lord. Therefore, my lord, we have some problem, my lord. So many person, my lord, it is as per, I am not sure, my lord, more than 1,000 person.
Be sure and come back. You have two options, either to withdraw or I pass an order. This kind of speculative writ petitions will not entertain. I'm sorry. You cannot say that I think there are people who are file a writ petition and see what happens. Court will issue notice, they will come up. If you succeed, fine, otherwise also it is okay.
But without the publication of the final or the.
Why you show me what is your right to know the results of others? I can understand if they said that they will not let you know what is the outcome of your participation. Correct. But how come you want to know the outcome of others participating in the selection process? What is your right to know that?
My lord, because my lord, we are appearing in the examination. This is the public at large has appeared in the. My lord, it is minimum, my lord. Actually, Supreme Court has observed in that, my lord, without the.
Where Supreme Court is observed saying what?
Without the merit list or the 4, my lord, paragraph 4, my lord.
Paragraph 4.
4, my lord. Very small judgment, my lord.
Yes.
The question, therefore, it is whether the view taken by the High Court is correct in law. When we ask the learned counsel for the appellant to place before the merit list to substantiate the stand taken in the affidavit file, in that behalf, the learned counsel was unable to place before us the merit list except the publication in newspaper that the candidate were selected on the basis of their merit. In view of the finding recorded by the High Court that no merit list was prepared, and in spite of the opportunity having been given, the government failed to substantiate that the merit list was in fact prepared. We find it difficult to accept the averment made in the affidavit. Under these circumstances, we proceed on the premise that the merit list has not been prepared and the selection came to be made on the basis of the education qualification required for the job, and in some department on the basis of pay scale available in the time. In this scenario, the question arises whether the appointment of the candidate is valid in law. When the service commission or the board selects the candidate, the normal criteria required preparation of a list of the candidates selected in the order of their merit and then recommended to the government for appointment to the post advertised for. In that behalf, it is always open to the executive to allow the selected candidate in the particular categories of service in the order of merit prepared and recommended as per the procedure and the application of roster and reservation, and on the basis thereof appointments be made to the respective department. Of course, it would be subject to the fulfillment of the qualification prescribed for the post. Since the government has not satisfied us as to how it adopted this rationale, the appointment of the selected candidate by pick and choose is an arbitrary exercise of power. Under these circumstances,
This is which department?
all departments. All departments.
Not specific to a particular department, it's a grade 4 category in except for the head.
Who has
and
conducted the selection?
Lordship, the state level recruitment commission for grade 4. Lordship.
Now, what do you have to say about the allegations in para 5? Why aren't you in a position to publish the list of selected candidates?
Lordship, it's whoever has applied
Hmm.
and on passing and against their roll number, only if they assess the portal, Lordship, they will it will be found that whether he is qualified or
So
not.
that he is
qualified.
saying,
Yes, Lordship, that's the process, and the comparative merit list is only for the purpose of having the grade pay, Lordship, as per the rules for the commission, and there is nothing anything about the merit.
no, but supposing you have selected ineligible candidates.
Lordship, at the time of submitting the application, they were required to, all candidates were required to give undertaking that if that they have this qualification as required for the post, and if any discrepancy is found, then it will be cancelled. Lordship, the commission part is only to find out the suitable candidate and forward it to the various department. And the department will, Lordship, before making appointment, they will verify their qualification and the documents, Lordship. If any discrepancy is there, Lordship, then as a consequential action
And
will be taken.
selection was done on what basis? What was the criteria for selection?
Lordship. Lordship, it was written in interview, and the qualification, Lordship, will find that page 18 of the writ petition.
Advertisement, Lordship.
So you file an affidavit responding to the,
Lordship, we have already filed our affidavit, Lordship.
where is it?
It was filed on Monday, Lordship.
It is not on record. Have you received copy?
Yes, Lordship.
You don't want to file rejoinder.
My lord, already what they
It
have
is
stated in the affidavit, my lord, this is our grievance, my lord. They have admitted, my lord.
Hmm.
Our grievance, my lord. We have taken, I have taken the instruction, my lord. They have said, my lord, beyond this, my lord, we cannot say anything because we are not know anything because till that, my lord, no merit list, no results sheet, my lord. Therefore,
We will not get into a roving inquiry, Mr. Borua. This matter will be closed at 2. Get the affidavit. You want a roving inquiry to be made. Throw some allegations and let the court find out. If everything is fine, fine, otherwise we gain. That will not do. That cannot be done. There may be some wrong here and there. That is possible. But then judicial process, you have to make out a prima facie case.
my lord, my prima facie is that, my lord, they.
You implicate those persons as parties and then we'll issue notice, ask them to show that what is their qualification. Otherwise, how does the court verify these allegations? How will the court verify these allegations? You see, you have heard what he has said.
My lord, he said.
According to him, everybody has the requisite qualification. If anybody is found not to have it, their appointment will not be given. That's all. We'll ask them to verify and then it may issue appointment order. Matter over. The only reason I'm putting it at 2 is that so that you get 2 hours time to apply your mind. Nothing else. There is nothing in this case.
No, my lord, all right, my lord, at 2, my lord, I will submit it.
For
Yeah,
admission item 3.
Just get the affidavit.
My lord, this item 3, my lord, pass through the matter for timing, my lord. My friend Dinad is appearing. He's on legs in another court, but he's coming, my lord.
Top of the list, no passover, nothing.
Yes.
Whether he comes or not, we'll go ahead with the matter. This is written top of the list.
My lord, one personal appearance matter. Oh, so
No,
he's
you
coming.
appear on his behalf. Yes, what is this case?
Lordship, petitioner was.
Do you know why these matters are listed as top of the list?
This matter is list,
Why?
Lordship.
Why is it listed top of the list?
After 2 years, this matter is listed, Lordship.
18 matter, my lord.
Huh?
For a long time, it was not listed.
Why it was not listed? There will be no accommodation in these cases. Yes, please argue.
Lordship, earlier occasion, Lordship, this honorable court passed the order, Lordship.
Hmm.
Order dated
Yes,
01/11/2019.
yes.
In compliance to this order, Lordship, they have filed additional affidavit.
What is your case? I'm disposing it off right now.
Yes,
What is your case?
petitioner initially appointed as investigator
Hmm,
in the year 1986.
hmm. Yes,
Actually, he was interviewed for the post of statistical assistant,
hmm,
but he was appointed as investigator.
yes,
Director Lordship, they have circulated a combined gradation list, year 1988. Page Lordship, 27. Annexure 3. Relevant page is Lordship 29. Gradation list of statistical assistant, allied cadre investigator, as on 1887. My name is serial number 5. Thereafter, Lordship, they have framed their Assam Fishery Service Recruitment and Promotion Order 1989. And here the post of investigator not incorporated. The petitioner post investigator is not incorporated. Lordship, kindly see the page number 68, Annexure 12. This is a letter of Director of Fisheries. The whole issue is discussed this letter, Lordship.
yes. Yes.
So my grievance is, Lordship, they have not
Where
incorporated
is the order of appointment?
appointment order of appointment, Lordship.
Yes,
Page 23. And call letter, Lordship, page 21. Call for interview for statistical assistant.
yes. Then,
My grievance is, Lordship, they have themselves not incorporated the post of investigator in their order of 1988 recruitment rule. Therefore, now I am retired, but that in my 32-year service career, I never been promoted, Lordship.
but you have now retired.
Yes, Lordship.
Then what can be done now? You can't be promoted now.
My benefit, Lordship.
What benefit will you get? When did you retire? Date of retirement?
They have stated here the date of retirement. Uh, 28/2/2019.
So how can this relief be granted to you? When you were appointed an investigator, you did not challenge it. You appeared in the interview for statistical assistant, but the appointment was made for investigator. You did not challenge it. You remained in service till 1990 when the order was issued. There also, this post was not included in the 1989 order. You did not challenge it. Only in 2018 April, you filed the writ petition. So from 1990 to 2018 is how many years? How many years?
I agree, Lordship, but I approached this court when the private respondent was promoted. She is junior most, Lordship.
That's right. That is because the rules did not have any avenue of promotion for your client. You knew the rules, you remained silent for 28 years. Today, after retirement, you want him to be promoted. How can that be done? Which is the legal principle that
Promotional
supports you? Hmm? It is not a right under the rule. You want the rule to be changed. Is it not? The 1989
That's it.
orders does not include the post of investigator, which is the rule which deals with promotion to the post of research assistant.
Page 31.
Page 31.
Type copy.
So promotion to research assistant, right?
Yes, Lordship.
What is the criteria for promotion?
Criteria, Lordship.
Yes. So is that all? Anything else you want to add? You want promotion to which post?
Research assistant.
Show me what is the criteria for promotion.
Lordship, I'm not getting here
Hmm.
my petition.
So the relief you want cannot be granted now. It's too late in the day. That is not permissible. If your client was in service, then we could have tried something, but he has now retired.
Is eligible for promotional benefit, Lordship.
Show me the law. Which is the law which says that? He has missed the bus.
Lordship,
Somebody is there behind. You want to talk? Go and talk.
Lordship, my senior is in court number 18, Lordship.
Who is your senior?
Adil Ahmed.
Right. You want him to come? We'll wait for him. Tell him that the judge is waiting for you. But he'll come or he'll not come.
He'll come.
Then we'll wait for him. Let him come. Yes.
Item 4.
May it please your lordship.
Top of the list. This also.
Basic case was that manner 2018 March, he was last transferred. And by the impugned order in January 2018, within 10 months, he was retransferred again. We contended that this is in violation of the guideline.
So this is infraction.
In course of time, it has become.
Also, we have filed my additional affidavit. Also, what happens is this chief executive officer is the authorized person to transfer the employees of the Assam State
There
Marketing.
is some stay order.
It was,
Yes, Lordship, that's a stay order. Rule 610 of the Assam Agriculture Police Market empowered the chief executive officer to transfer and posting the employee of the board, Lordship. As for the approval of the board chairman, Lordship. Accordingly, which was done, Lordship.
All right, take down. Heard Mr. B. Chakravarti, learned counsel appearing for the writ petitioner. Also heard Mr. N.J. Gogoi,
Or
learned
respond number 3 and 6.
counsel representing the respond numbers 3 and 6.
Sorry, Lordship, 2 and 3.
2 and 3, okay. 2 and 3. You are appearing, Mr. Dhar? Chandan is appeared for respond number 1. The writ petitioner is an employee
No, only 1, 2 and 3.
working under the respond number 2. Full stop. While he was posted at Dharam, he was posted at Dharam as what?
as manner marketing inspector.
As marketing inspector, by the order dated 5/3/2018, the petitioner was transferred and posted at Ajara Center under the Guwahati subdivision of the Market Committee. Full stop. The aforesaid order of transfer was issued within 10 months of his joining at Dharam. Full stop. As such, alleging frequent transfer, the petitioner had approached this court by challenging the
No, manner,
no, sorry.
actually,
While he was posted at Dharam by order dated 5/3/2018, the petitioner was transferred and posted at
Yes.
Ajara Center,
After that,
and thereafter, my lord,
Guwahati subdivision market committee, in which post he had joined. However, on 14/1/2019,
you are
the
transferred from
petitioner was again transferred from Ajara and posted in the Jorhat district
Regulated Market Committee.
Regulated Market Committee. First up, aggrieved by the order dated 14/1/2019. The petitioner had approached this court by filing the present writ petition alleging frequent transfer in violation of the transfer policy. Full stop. After taking note of the grievance expressed in this writ petition, the learned single judge had passed order dated 01/02/2019 suspending the operation of the transfer order dated 14/1/2019. Consequently, the petitioner continued to serve at Azra on the strength of an interim order passed by this court. Full stop. This writ petition was last listed on 21/5/2020 when the interim order was extended. Full stop. Today, when the matter is called up, Mr. Gogoi has pointed out that the impugn order of transfer has already spent more than 3 years, and therefore no live issue survives for adjudication in the present writ petition. Mr. Chakraborty, learned counsel for the petitioner, has also agreed to the said proposition. In view of the above, this writ petition stands disposed of by granting liberty to the departmental authorities to pass fresh order of transfer in respect of the writ petitioner hearing. As per the departmental norms, the interim order dated 1/2/2019 stands vacated. Writ petition stands disposed.
So there is an IL of it. We filed the IF for vacating that. Maybe this
In view of order passed here, highest stands disposed. Yes.
highly obvious.
Call item 3. Item 3, you call?
Item 3.
Yes. Mr. Ahmed, you see, you had a very good case,
Yes,
but today nothing can be done.
yes. he has
Either you
already-
convince the court on the legal front or take your seat, I'll dictate the order. Because now there cannot be a direction to amend the rules, then consider your case for promotion, notionally promote you, then give you the service benefit. That is not possible today.
Yes. The question is that he has filed this before retirement.
You may be, but it is not
Due
that
to
under,
some-
it is not that the rules permit.
Yes, yes.
Now the rules will first have to be amended.
Government of Assam has already mentioned in their affidavit, if the court direct them, then they will amend the rule, my lord.
No, first the rules be amended, then we'll see.
Then the amendment, that affidavit is there,
Where is that affidavit?
affidavit filed by Commissioner and Secretary. And at page 5, after considering the entire matter, taking note the order, Honorable High Court dated 11/1/11/2009, 257280, government will reconsider the matter of promotion of the writ petition. It is now in the post of research assistant with election norms as prescribed, serial number 7 of the Schedule 1 of Assam Fishery Service Recruitment and Promotion Order 1989. In the light of provision, Rule 14 of state regulation, provision submitted by Directorate Fishery, they have already forwarded proposal. Due to if the Honorable Court direct.
No, but that was done during, while he was in service.
Yes.
Now he is
while-
retired.
Now retired.
How can now the relief be granted to him?
Let them reconsider, my lord, matter may be remanded back.
Show me the law which permits that. They
No.
should be able to do it under the law.
That is the problem.
We can't direct them to do something which is illegal.
Let
You have to
this-
show that this is permissible under the law. So direct, I will do that, no
Yes.
problem. But where is the
Pet-
law which supports this kind of?
Petitioner had never been promoted. Yes,
Oh, these are matters which were live when he was in
when
service.
I was in service.
Now it is not live.
Matter was is not listed due to some
After
technical.
after retirement, only those issues where the rights are crystallized
Yes,
while in service.
yes, yes.
Only those issues can
Yeah.
be considered.
Definitely.
But here his right is yet to crystallize.
Yeah.
First, even if he is considered, he may not be promoted.
Yes, let
So-
me take instruction, my lord, at least one. From my-
What instruction you want to take? This is a
No,
legal
my-
point.
Yes, my lord, clear case, but at least instruction may be given.
Day after tomorrow. Not beyond that. You
Yes.
either show me the law that it is permissible or we'll close these matters. These are pending since 2018 unnecessarily. Heard Mr. A. Amir, counsel for the petitioner who seeks posting of this matter again day after tomorrow, that is give the date, so as to enable him to obtain updated instruction. Mr. R. Leonard, government advocate, is present on behalf of the official respondents.
S. Kakoti, my lord, for
Mr.
respondent number
S. Kakoti has appeared for respondent number 5. Have you understood the point?
Yes, yes, I am.
If his right had crystallized
Yes, yes,
and it was a illegal application of a law or
Yes.
non-application of mine,
yes.
then we can say that redo it and give him the benefit. But now if he is considered,
Consider.
he may not be
Will
promoted.
not be.
That cannot be done today.
Yes,
Either you give me a Supreme Court decision which specifically is on the point, or else we'll close the matter on Thursday.
My lord, I'm retired now. That may be recorded now.
Huh?
Respondent number 5 is retired now. That may be recorded.
All right, that's fine.
obliged.
Item 6, Parker letter.
May it please, your lordship.
We'll take it after finishing the other
Fine.
matters before hearing. Just
Fine.
before hearing, we'll
Fine.
take it.
Item 7.
With all respect to the senior counsel, my lord, may peruse the earlier order dated 21/11/22, my lord. Your honorable court directed me to take some instruction, my lord.
Showing respect is good, but why suddenly respect to?
No, I
senior-
have already informed, my lord,
Acha.
that earlier it was mentioned by the petitioner. Because of that, my lord, the instruction was given to me that whether can be converted to compulsory retirement or not.
Yes, what is the instruction?
My lord, because my lord, he joined in 2006. My lord, from 1st January 2004, new pension scheme come, my lord. So my lord, he, if also converted, he cannot get the benefit of pension, my lord. So my lord, it may be hard on merit, my lord.
Then we'll hear it on merit.
Yes.
When?
I will read today or day after tomorrow, my lord.
All right, day after tomorrow, but now onwards, we'll have a list of 100 cases every day.
My lord.
100 cases, everybody will come and sit here. How can it be done day after tomorrow? There are other matters fixed. You be reasonable in asking a date, Mr. Sharma. Otherwise, we'll randomly fix matters.
Any hearing day.
There will be 100 cases, you will be sitting here the whole day.
2019 matter.
All right. Heard Mr. R.P. Sharma, learned senior counsel appearing for the lead petitioner. Also heard Mr. K.K. Parasan, learned CGC appearing for the respondents who submits an instruction obtained in terms of the order dated 21/11/2022 that since the petitioner had joined service in the year 2006, by which time the NPS had kicked in, his services, his order of dismissal cannot be converted into an order of compulsory retirement. So as to give him the pensionary, so as to give him any pensionary benefit. As such, the learned CGC prays for hearing and disposal of this writ petition on merit. Since this is a matter of 2019 and in view of the urgency expressed in the matter by the learned senior counsel for the writ petitioner, register to list this case again
On 20th of June, my lord, 20.
20th of June.
20.
20th of June. In the column of disposal at admission, within course disposal at admission.
Problem.
Here, your lordship, the matter has been listed for the first time since 2021. We have received the instructions, the parallel comments. May I seek 2 weeks time to file the written
What is the matter about?
affidavit?
Dismissal of service.
Dismissal from
Dismissal. Same date, my lord, because they both came together. Heard Mr. R.P. Sharma, learned senior counsel appearing for the petitioner. Also heard Mr. D. Bora, learned CGC, appearing for the respondents who prays for posting this matter again on 20th June 2023, so as to enable him to file counter affidavit. Prayer allowed.
And my lord, possible disposal also, it is having hearing discussion.
No, that the first he has to file counter affidavit.
Admission.
Wait, please, your lordship, in the last occasion, we are advised that whether the both parties are ready for mediation, my lordship. In regard my part, my lord, I am ready.
I could not contact the girl, my lord, because the telephone number which I have got is not ringing, my lord. So I may be allowed time to procure her number and contact her, my lord.
How much time you want?
Where she is, whether he is at Guwahati or the Tezpur, that also I don't.
That is okay, but how much time you want?
2 weeks, my lord.
Huh?
2 weeks.
My lord, sir, as I am ready, my lordship, after 21st of June, my lordship, he will come, my lordship.
21st of June.
Yes, your lordship.
All right, then we'll post it on next Monday. In the meantime, you contact.
Next
Coming Monday.
it will be good.
Huh?
I'll try, my lord, whether I can prove or not. I'll try. Because I am to procure her phone number by any, because she belongs to Kharupeti of the Dharan district. Earlier she was in the maternal uncle house, whether he is here or there, they phone her. So I am to contact the advocate in the Tezpur to procure her number, my lord.
She always visit in the Tezpur, my lordship, in all the cases, my lordship. Perhaps I have seen in the last date in the court premises also, my lordship.
Or we'll allow the petition on the next day. If she doesn't respond, then we'll allow the writ
No,
petition.
no, she will respond, my lord. I may be allowed time. I'll
Yes.
definitely correct.
Next Tuesday, we'll fix it. Miss
MSB, Bhuya, my lordship.
MSB Buyal and counsel appearing for the petitioner submits that her client is ready to go for mediation so as to arrive at a negotiated settlement of the dispute involved in this case. First of Mr. K. Sharma, learned counsel for the respondent, however, submits that he has not been able to establish contact with his client so as to ascertain her willingness to go for mediation. First of, in view of the above and on the request of Mr. Sharma, this matter is directed to be posted again on Tuesday, next Tuesday, dated 30th of May 2023, so as to enable him to seek instruction. 1 week time,
My lord,
1 week time you are getting. Yes.
She is working in Vinayak Furnishing, that I know.
All right, we'll pass orders accordingly.
Obliged, your lordship, highly obliged. Item 10.
Here we have made a challenge to the downgradation of the remarks in the APR of the petitioner by the reviewing officer, my lord. The reporting officer had given a remark of above benchmark, very good. The reviewing officer has downgraded that remark to good, which is below benchmark, based on extraneous conditions such as taking into account incidents which are after the APR period was over, and despite there being orders from the Director General not to take into account certain incidents. If that part is considered, my lord, the remarks of the reviewing officer would go and the reporting officer would stay.
How long will you take to argue the case?
My lord, in half an hour, because I have to go through a few dates.
Choose a date. That will be admission, disposal and admission date. Because we'll first go through parted matters. Certainly we can start. And nowadays there is no hearing. No matter will be heard.
Okay.
Because everybody wants disposal and admission. So hearing is gone. So now we'll create a new category, disposal or admission, which means hearing. In a new name.
It will be in a hearing.
Huh?
It will be taken up for hearing, my lord, lordship's convenience, but only thing is, my lord, since it's an APR, he's suffering on his promotions also. I think that in my lord, any date for a full-fledged hearing, my lord, I'll be. Hurry on that angle is not
I
there.
have already filed affidavit and
Their affidavit is record,
any death as per convenience of the.
all the records, all the APIs required are here.
Mr. R. Majumdar, learned counsel for the petitioner, and Ms. B. Sharma, learned CGC appearing for the respondents. It is submitted at the bar that this matter is ready as regards pleadings and therefore can be taken up for disposal at the stage of admission hearing. In view of the above and on the request of learned counsel for both the parties, after summer vacation,
If it could be a little early, my lord, otherwise, lordship's convenience, court's convenience, my lord, there is no difficulty.
have it on 18th July. Let this matter be listed on 18th of July 2023 as a fixed item in the column of disposal on admission, at the stage of admission hearing, within courts, disposal at the stage of admission.
Obliged.
I'm obliged. my lord.
The parties to come prepared for final disposal, for final hearing and disposal of this matter.
I'm obliged.
May it please your lordship. This matter, your lordship, on that day, your lordship has heard it. With regard to retrospective seniority that was given to the respondent number 5. Your lordship, before going into the matter, I would like to hand over the list of points. That day it was some corrections were required. The point that comes up in this matter is whether the petitioner is entitled for the retrospective seniority with promotion after his promotion was earlier set aside by the Sonbur court being illegal.
So, Mr. Manan,
I got these.
this will take some time. We'll take it up today,
Yes,
but let me finish the other matters, admission matters, and then we'll take up. There is a parted admission and then your
Mr.
matter
Chakraborty's matter is also. Okay, after that.
after that.
May it please your lordship. My lord, I am appearing in item number 12. My matter pertains to, my lord, promotion from grade 2 to grade 1 of stenographers. And the recruitment rules provide for graduation. However, the undergraduates are sought to be promoted. That's why we are before your lordship. And they have filed a affidavit, we have filed a reply, pleadings are complete and I'll be praying for a final disposal matter.
Then wait, when your turn comes. Pass over.
May I please? Kindly pass over the matter for the time being, my lord. By sending me the you can select and some matter for me.
What is this matter about?
My lord, matter is regarding, my lord, non-payment of the SCA. But this is regarding.
1516 is a sample.
Yes, who is appearing for the respondent? You are appearing?
Yes, I appear respondent ICR.
You have filed your affidavit.
Yes, I filed affidavit earlier.
And any rejoinder?
It's your requirement, my lord.
You have filed. So pleading is complete. We'll post it for disposal at admission hearing. It can't be done today. Yes. Heard Mr. A.K. Borolari, counsel appearing for the writ petitioner in both these petitions. Miss
Jupiter does.
Jupiter Das, learned standing counsel ICR. ICR has appeared for numbers Respondent numbers 1, 2, 3, 1, 2, and 3, and Miss M. Kalita, learned, Standing Council Agriculture, Assam Agriculture University, for respondent numbers 4, 5, and 6. It is submitted at the bar that this matter is ready as regards pleadings and can be taken up for disposal at the stage of admission hearing. In view of the above, registered to list this case again on 18th of July 2023 as a fixed item in the column of disposal at admission stage.
Obvious.
My lord, in this matter, Mr. Yukenari, he is on legs, my lord. So I may be taken up after.
No, but is it for disposal then?
My lord, I had ordered it at 25/1/2023. Your lordship directed that on the next date, the interim prayer will be considered 25/1/2023. And thereafter, my lord, it could not be.
Passed over.
Obliged, my lord.
Item 17, item 17.
No, there are admission matters.
Lordship,
In the supplementary. bill. Why haven't you called it? Yes, please. Just a minute.
May it please your lordship. Your lordship, on the last occasion, your lordship had directed the respondent authorities number 6 and 7 to file an affidavit.
Which is your matter?
30, your lordship. Item number 30, your lordship.
Submit.
WPC number?
WPC number 339A of 2021.
My lord, here, my lord, I appeal for the Dibrugarh University. The affidavit has been sent for signatures, my lord, this day. I'll have it within a day or two.
Mr. Sharma, are you in touch with your client?
Yes, your lordship. Yes.
Who is instructing him? Who is instructing your client? Or who is receiving instruction from the client? You or somebody else?
Somebody else.
Who else?
My colleague, Mr. P. Bharadwaj.
Is he around?
He's not around as of now, your lordship. But if your lordship needs to convey, I'll convey the appropriate.
No, is he in the court premises?
He will be in the court premises in a short while, your lordship.
Please check up. This matter has been listed for some other purpose. The writ petitioner is directly sending messages to the judge.
I apologize for this. sir.
So
This is
we
not-
would like to take some action in this matter.
This is not.
Call him, tell him to come personally.
Okay, I'll inform.
And
you about that.
we would like to. So you call Mr. Bharadwaj,
I
let him
will,
come.
apologize, your lordship. This.
We'll take action in the matter. We'll call him personally. He has to come.
Yes.
Yes.
Lordship, Mr. R.K. Dev Chaudhary is appearing and he is engaged in court one in Mia Matter, Lordship. So
It will
preferably.
be very
with date
difficult. We will have to pass an order after hearing.
The last August.
This can't go on. We can't help it. The court businesses cannot be scuttled like this. Yes, please start.
May I inform him, Lordship? May I-
You do whatever you want. We will not wait for anyone.
The petitioner were the casual employee of Brahmaputra Board. They were disengaged. They raised an industrial dispute and award was passed in their favor. And that award was upheld by the Brahmaputra Board. And during pendency of that award, this honorable court passed an order under section 17B to pay the last wage drawn. Now, my lord, instead of paying that last wage drawn, my lord, they have directed us to join in the service with the for an amount of rupees 5,000 that was drawn by me as last wage. That order, your lordship will find that at page 104.
Page one. Page 104.
104.
Yes. No, why it has come for orders today? What is this IA for?
Actually, my lord, I filed an application
Ah,
before this honorable court
अच्छा, there is a IA. There is a IA.
for grant of minimum wage. I get a 90.
This is the IA, I think. What is the repetition? There is a WPC 7845 of 2018. Just a minute, Mr. Das.
Oh, no problem.
Acha, let me see what is the prayer in the IA.
Yeah, so the extra copy আছে আমার কাছে। নাই দেখলে আসছে।
You got it? Thank you.
আছে এটা?
Yes, yes, it is there. 1 minute, just 1 minute.
আমাদের 22 অর্ডারটা কি চেঞ্জ করছি তো? No,
Just 1 second.
কি বলো?
So it is covered, that this prayer in the IA is covered by earlier order.
But so far, IA.
Where is the order dated?
Page 101,
Where is the order dated 14th of May 2019?
15th of 12, 15/12.
14th of May 2019. Please see para 3 of your application. Second last line.
Oh, Annexure B, that
Annexure
is
B.
at page 29, Lord. Relevant page is 53. It is first order, Lord. That was, this order was passed. Last paragraph 16.
Yes,
In view of the above, all these applicants are allowed by the management to pay full wage last drawn by the applicant, inclusive of maintenance allowance as provided, if any. Management would be at liberty to applicant to any other project at the under. So this liberty was granted.
so you
I-
want a similar order in this IA?
No, actually, Milord, I am not sure. Milord, actually, I am, so far this order is concerned, that is at page 104. They have directed me to join, asked to join. We have joined. But they are paying our wages at the rate of rupees 5,000, which is far below the rate of minimum wages. So I would like to have the minimum wage. Because so far 17B is concerned, 17B is that during pendency of the REIT application, court passes an order that you should pay the last wages drawn. So while passing this order, the person concerned did not serve under the employer. Now, but here they have constituted that the court passed an order to pay the last wage drawn. They are paying the last wage drawn, no problem. Now they have called us to serve them with the salary that was drawn by me when I was dismissed, say in the year 2002 or 2003. That was the payment made to me as rupees 5,000. So I have been directed to work under them with the pay, with the wages, which
Where is the order? Where is the order?
Blood?
Where is the order? Page number 10?
104. No. Last 3 lines, Lord. Therefore, it is requested to make necessary arrangement to deploy the above laborers under Guwahati Division Brahmaputra Board consolidated monthly remuneration of rupees 5,000 as their monthly 5,000 remuneration as top. In the last occasion, they also paid me to that. Then we approved before this. Now, if your lordship come to the page 66.
Where is the order dated 15/12/2021? Passed by this
15,
court.
that is on page 101. Hmm. 17 feet of a shot. This order By this order, management was directed to comply the provisions of 17B. So your lordship is required to go through the provisions of 17 under 17B of the IG Act. Mail 17 video.
1 minute. Yes,
Now, your lordship, if you go to the provision 17B,
right. Yes,
where in any case, the labor code tribunal or national tribunal by its award directs reinstatement of any workman, and the employers prefer any proceeding against such award in a high court or Supreme Court, the employer shall be liable to pay such workmen during the period of pendency of such proceeding in the High Court or the Supreme Court, full wages last drawn by him, including any maintenance allowance admissible to him under any rule if the workman had not been employed in any establishment during such period, and if an affidavit by such worker had been filed to that effect in such court. So initially, my lord, this honorable court, Honorable Justice Protester Singh passed an order whereby the management was directed to pay last wage drawn. Now, and while passing that order, the Honorable Justice Protester Singh made an observation that you were at liberty to deploy them in your service. Now, they have deployed us in their service. But while deploying us, my lord, they paid the last wage drawn, not the current wages, or not the minimum wages even. At that juncture, my lord, we came before this honorable court by filing an application for grant of minimum wages. When we filed this application for grant of minimum wages, what they have done, they withdrew their earlier order. Then we have to come again before this honorable court for due compliance of 17B. Now the Honorable Justice Medhi has passed this order on 15/12/2001. Now they want to implement that order. While implementing that order, again they have resorted to the earlier activities by calling us to join to serve them at the rupees of 5,000 only. Now, my lord, I have annexed this minimum wages, my lord. That is page 66.
What should be the wages according to you? What should be the minimum wage?
No, my lord, I have annexed the one notification. That is at page 66. Though it is increased substantially, till then, my lord, this order was, this minimum wages was fixed on 23/9/2019. Now, if your lordship come to page 67, That was prevailing rate for an unskilled worker. 603 per day. So it is more than 18,000. That too in the year 2019. For skill, 666. So it comes to about 19,000. For unskilled, skilled, 730. This is not applicable for us because it is for the clerical.
Yes, what do you have to say? You have engaged them to work, so you have to pay them the minimum wage.
Yes.
Lordship, I'm not aware of. Yes.
All right, then
Just a-
take your seat, we'll pass the order.
Lordship.
Ms. Sharma, this business is not going to work out. You can't ask the court to wait till the council is free. This will not work here. The DSGI may be busy somewhere, he has to make alternative arrangement. We cannot wait. The court's procedure cannot wait.
If Lordship, his part, he may be allowed to submit his part on Thursday, Lordship.
But I am passing the order at 12.
Your Lordship may kindly consider
He is arguing, Lordship.
Article 23.
Come at 2, we'll have it at 2 then,
Lordship.
not beyond that.
No.
If at 2 it doesn't come, we'll mention it and we'll go ahead.
So in this regard, Article 23 is pertinent. No person should be compelled to work forcefully.
At 2.
So I have for correction of order, Lordship, passed by the Honorable Justice L. Jamir, Lordship.
Let it go before that court. This IA has been filed with a prayer for correction of an order dated 30 for corrections in the order dated 30/11/2022 passed by the learned single judge in WPC number 4920/2018. Since the learned single judge bracket just Honorable Justice Lanusunkum Jamir bracket close is presently available, registered to post this matter before the appropriate bench.
Hello.
So then we'll part out which matter. All right, so I'll just rise for 5 minutes and then.
May please. Your Lordship. My lord, has heard this matter at length on many occasions. The one question which your Lordship has put me, it regards section 33 and what would be the consequences, my lord. Rest, my lord, I'll just briefly indicate, refresh your Lordship with the points which I argued, my lord. My lord, the award which has been passed is an proceeding under section 2A of the Industrial Dispute Act. My lord, the proceeding under 2A can be initiated only by a workman. Now, my lord, the admitted position is that the respondent number 5, at the time when he was dismissed, he was the chief manager of HR and admin, which is the second position to the general manager. In the affidavit opposition, he admits this position. However, he contends that in view, but he was never been given any administrative work, and he was always been given as a work of the club. And he refers to the staff regulation. I have placed before your Lordship on the other day, the staff regulation of the bank, which says, my lord, the chief manager is an appraising authority who has a control over the promotion and recruitment. And therefore, my lord, the judgment which my learned senior friend has relied to show that mere designation will not confer that he is a workman. It is the nature of work. In the same judgment, whether it has been contended that if the person has been designated with supervisory work, then he doesn't come under the definition of the workman. Now, under that position, my lord, the proceeding which was under which the award, impugn award has been passed, my lord, that lacks jurisdiction. And therefore, my lord, the award is none as. Secondly, my lord, assuming, my lord, the jurisdiction point is not taken by your Lordship, my lord, the labor code under section 11A has been conferred a power to adjudicate on the matter when regarding a dismissal of an employee. Section 11A clearly says, my lord, to set aside and dismissal order, the labor court has to arrive at a satisfaction, which requires an adjudication. Bare perusal of the award, your lordship will find that there was no reasoning, there was no reasons cited. Only because it is an ex parte order, the dismissal order was set aside. So therefore, my lord, the section 11A, the power has been violated. Now look at the third point, which my learned friend has argued regarding the consequence of section 33(2)(b). Now, section 33(2)(b), in terms of the constitutional bench judgment in Jaipur, well, there's no confusion left that the approval has to be taken. But your lordship will, if your lordship kindly takes up section 33 for a moment. Well, this section 33 is a protection against, which is guaranteed to a workman. Madam.
Section 33 of the Industrial Dispute Act.
Yes, madam. The respond number 5 contains that there is a protection under 33(2)(b), and which puts that if an order of removal is being passed during a pendency of the reference, which is not connected to the dispute, then the approval has to be taken by the authority. And if the approval is not taken, that order of removal is inoperative. Now, my lord, will kindly find section 2(b), my lord. This is a protection which is made available only to the workman. So again, the issue comes down to whether the respond number 5 is a workman or not to get the benefit of section 2(b). May I read, my lord, 2(b)?
Yes.
During the pendency of any such proceeding in respect of an industrial dispute, the employer may, in accordance with the standing orders applicable to a workman.
You're reading from 33?
My lord, section 33, 2, subsection 2.
Yes.
During the pendency of any proceeding in the respect of an industrial dispute, the employer may, in accordance with the standing orders applicable to a workman concerned in such dispute. My lord, mark this word, workman. In such dispute, or where there are no such standing orders in accordance with terms and conditions, whether expressed or implied, between him and the workman, alter in regard to any matter not connected with the dispute, the condition of service applicable to that workman immediately before the commencement of such proceeding, for any misconduct not connected with the dispute, discharge or punish, whether by dismissal or otherwise, that workman, provided that no such workman shall be discharged or dismissed unless he has been paid wages for 1 month and an application has been made by the employer to the authority before which the proceeding is pending for approval of the action taken by the employer.
Yes.
So this protection, my lord, is confined to a workman. Now, my lord, the issue which we have raised, that the respond number 5 doesn't come under the definition of workman as it is defined under section 2(s) of the Industrial Dispute Act. And therefore, my lord, this section 33(2)(b) protection is not available to here. Moreover, my lord, the award has been challenged under an application under section 2(a) and not under section 33(a). 33(a) provides
Yes.
my lord, where an employer contravenes the provision of section 33 during the pendency of a proceeding before conciliation officer, board and arbitrator, labor court tribunal or national tribunal, any employee aggrieved by such contravention make a complaint in writing in prescribed manner to such conciliation officer or board. The conciliation officer or board shall take such complaint into account in the mediating in and promoting the settlement of such industrial dispute. To such arbitrator, labor court tribunal, national tribunal, and on receipt of such complaint, the arbitrator, labor court tribunal, or national tribunal, as the case may be, shall adjudicate upon the complaint, as if it were a dispute referred to or pending before it in accordance with the provisions of the Act, and submit his or its award to the appropriate government, and the provisions of this Act shall apply accordingly. So, well, if the order of removal because of non-compliance of 32(3)(b) is inoperative, there was no question of challenging in a proceeding under section 2(a). So, in my humble submission, my lord, the respond number 5, being not a workman, my lord, the protection under 33(2)(b), which is available to a workman in order to prevent victimization and unfair labor practice, is not, my lord, applicable in his case. Moreover, my lord, the respond number 5 has nowhere made out a case that the dismissal of his from his service is an unfair labor practice or a victimization. My lord, the Honorable Supreme Court, my lord, I've relied on a judgment I have quoted in my written argument, where the Supreme Court very clearly said that the allegations of victimization and unfair labor practice are serious allegations, and it has to be pleaded and proved. It cannot be assumed from inference. And therefore, my lord, the respond number 5, though has tried in my petition to bring 33(2)(b) to projecting that it is a case of victimization, well, that in my humble submission, that is not happening. That's all, my lord. So in my humble submission, my lord, the award which has been passed by the Labor Court, my lord, is without jurisdiction, and therefore it, my lord,
You have already handed over your written submissions.
my lord, I'm giving it. The the staff regulation I have handed over. If your lordship wants, then I can give you one more copy.
Yes, please, please. Please.
And I've mentioned 2 judgments, my lord, which the copy I'm giving. I marked the paragraph. On the point that as it was not an application under section 33(a), but an application under section 2(a), the scope of that both the sections have been explained by the Honorable Apex Court. That's all. Highly.
My lord, so far his argument about the workmen, that the Labor Court did not have the jurisdiction. Lordship may have a look at the writ petition. There is no ground in the writ petition that the award is bad for want of jurisdiction. The ground of challenge of the award is that the Labor Court did not give any reason. So the issue of jurisdiction has not been taken
So
up.
what do you have to say on that? Labor Court did not give any reason.
My lord, I am not on 11A, which my friend is saying, arguing. I'm not in 11A. My case is that.
So your case is it is bad as being hit by 33C.
Yes,
But if you don't succeed in 33C,
my lord.
then you agree that the award is bad.
Then it can go back.
Okay.
But the issue as to whether he's a workman or not, I have given it in my written submissions, my lord. My lord, they have not pleaded that before the Labor Court by filing a written statement, narrating the scope of my duties. So firstly, whether I'm a workman or not, the law says it is not dependent on the designation, it is the nature of duties. So one cannot presume me to not to be a workman.
That you are correct. You have argued elaborately on this point.
Yes, my lord, and I have given it on the.
There are Supreme Court decisions also on that.
My lord.
But the question here is, if you say that despite being designated as a manager, you were doing clerical work, then the onus is on you or on the bank to show that you are doing clerical work, and the vice versa. That's the question I'm asking.
My lord, the onus primarily is on the management to show that I'm not a worker. And if they allege that this is what you do, then it shifts upon me to bring contrary evidence. Firstly, it is the party alleging has to establish that I'm not a workman. First, pleadings supported by evidence. That pleading is not there. The opportunity was given to the management to bring on record the pleading and the materials by passing an order. That was not done. And my lord, their argument they cannot have the argument by blowing hot and cold. If I'm not a workman, then they cannot argue anything more, my lord. If they are arguing that 11A was not properly exercised, that exercise has to be carried out in respect of a workman only. Ultimately, if their argument is that 11A was not properly exercised, the power to exercise powers under 11A by the labor code is in respect of a workman. So on one side, they are saying I'm not a workman, and they are saying that 11A was improperly exercised. Well, they cannot have both the arguments simultaneously, my lord. And in my written submission, I have given why I cannot be considered not to be a workman. There are two reasons. Firstly, the earlier round of litigation where my issue was pending, I participated, they adduced evidence, award was passed, they have not raised that issue. And the second order is continuation of the earlier one. The reference was my suspension was an issue. And the present award is in respect of my removal from service, which is a continuation of the process. In the earlier round, my lord, they have not challenged my status. They have contested, an award was passed, that award was also not challenged. So the issue of whether I'm a workman or not has attained finality. It cannot be gone into now, my lord, with that too without any pleading sermon.
No, but in the earlier round, was it an issue?
Yes, whether the suspension of respondent number 5 is justified. This is a different thing. Labor court held that it was justified or it cannot be answered in view of the High Court's order. But the other issues with regard to wages or deduction, there is a categorical finding that the respondent number 5, who was the general secretary of the association which raised that dispute, and the other persons are workmen. May I draw your lordship? That's what, my lord.
Where is it? Which page?
My lord.
Page 242, my lord.
Two?
Page 242 of the affidavit is the award.
Two 42, you said 242 is something else.
My lord,
In my copy, it is marked as 242.
242 is a part of an affidavit.
Yes.
Affidavit. They have
But
annexed
the
the
earlier award, my lord.
reference, the award of the reference case number 12 of 17
Hmm.
in 242, which they are
My lord,
referring
they
as
come to page 249.
249.
Yes. Before that, my lord, it is the answer of the labor code in respect of issue number 2. Lordship may have a look at what issue number 2 is all about. My lord. My lord may have that issue number 2 at 243. Issue number 2, whether the management of Industrial Cooperative Bank Limited is justified in deducting the wages of section of workmen stroke employees for 1 day, that is on the day of alleged illegal strike on 25/8/2016, and making payment to other section of employees. So in answer to the issue number 2, lordship will find at 249, the management's plea is that the issue number 2 is a vague issue, as because in the reference, the number of employees from whom the bank deducted the salary has not been cited. The facts behind this issue are that being aggrieved by the suspension of General Secretary of the Association, that is the respondent number 5, the employees of the bank observed 1-day strike on 25/8/2016. There is no dispute that the management took action against the striking employees by imposing penalty of deduction of 1 day's salary. The General Secretary of the Association brought this issue before the Assistant Labor Commissioner to so-and-so. The minutes of the Assistant Labor Commissioner cum Conciliation Officer, which has been exhibited as Exhibit E, speaks that the employees who admitted their guilt and assured the management of not taking part in any future strike. The penalty levied from the striking employees were returned back. My lord, this is very important. There are 9 workmen, including the vice president, the general secretary, and the office bearer of the association, who refused to confess their guilt. Being unable to arrive at a conclusion of this matter, the assistant labor commissioner so-and-so threw it to the management to decide the fate of this employee who did not confess their guilt. It is to be mentioned that in that conciliation, so-and-so, so-and-so. So, my lord, the last line says that 9 persons, the vice president, the 9 workmen, my lord. The 9 workmen, there are 9 workmen, including the vice president, general secretary, and office bearer of the association. So, my lord, my submission before lordship is that the labor court in the award has come to a conclusion that the office bearer, that is the vice president, the general secretary, that is the respondent number 5, and other office bearers are workmen who did not admit their guilt. So
that, Mr. Chakravarti, I must say that will be a little difficult to accept. Because to hold that XYZ by virtue of discharging a particular function would be treated as a workman within the definition of such and such provision. That is one thing. If that is done, then there is no doubt about your argument. But the labor code casually referring to someone as a workman or not, that cannot constitute a res judicata on that issue.
why I am submitting, my lord, this issue of workmen was never pleaded or raised earlier when the issue of suspension was and the other issues were in the labor code. And that,
So therefore, that's what I'm asking you. What is the principle that will come in? Therefore, it is he's a workman.
no,
They cannot raise this issue again.
yes, they can.
Then,
That issue they ought to have raised before the labor court. In
so if
spite-
they have not raised before the labor court, they cannot raise it before the high court. Is that what your argument is?
that opportunity was given. They have, number one, they have not accepted.
Mr. Chakravarti, that's the reason I had told the other day. I don't know whether you have read this judgment. If you have not read this judgment, either you don't know what you have argued in this case. Did I refer to the Onkar Mills
Yes,
judgment,
yes.
1977? Have you read it?
No, my lord.
Then you don't have any idea what you have argued. Because the judgment will be in completely different line. If you want to risk that now, it is up to you. Maybe you have an answer. Maybe you have an answer, maybe you have an answer, but if you do not read that judgment, then you will be in the dark. Whatever you are arguing, you will be in the dark, and it will be only for your personal satisfaction. Because that is where these aspects of the matter have been gone into very deeply.
May I have a citation, my lord?
Hmm?
The citation.
It is, I think it is reported in 1977 SCC. It is a case from Assam. I think the citation is Omkar Mills versus State of Assam or something.
Omkar Mills.
Yes, yes.
Find out. On the issue,
Perhaps His Lordship Justice Vivian Bose is the author of the judgment.
on the issue, my lord.
Jurisdiction.
Jurisdiction.
Up to what stage jurisdiction issues can be raised? Is there a waiver? What will constitute a waiver? What will not? These are aspects that have been dealt with in the judgment in details. So that is the reason perhaps I pointed
Yes,
it out on
Lordship
the last
indicated
day. That is the argument here. If he succeeds in showing that his issue either goes against you or was not decided, the matter goes back, as simple as that. The court is not going to any other aspect of the matter. The only way you can succeed on that is to show that this is barred by law. There you have to rely on established legal principles, which will preclude from this court from touching that matter. Not by saying that labor court opined that he is referred to him as a workman, so the matter is over. That argument will not be accepted. I'm making it very clear to you. So that I want to give you an opportunity to, because that's a very crucial issue. He has raised it and the court will have to answer it.
My lord, in my understanding, the writ petition is silent on this issue.
Mr. Chakravarti, all I'm asking is, I can close the matter today, And I don't know which way it will go, but this aspect of the matter will be dealt with in details. And the fact that the labor court in that order, issue number 2 says they are workmen, that is not going to clinch anything. That much I can tell you right away. Though the judgment is yet to be.
But the fact, my lord, that opportunity to establish and plead was given.
Okay, yeah, okay, fine.
That was given, and they, in spite of that time, they did not contest the referral. And
The issue number 3, my lord, which my senior friend is referring to. My lord, in that issue number 3 itself, it is very clear. He was a general secretary of the Industrial Cooperative Bank Employees Association. And there are two associations. One is a workers association and one is the employees association. My lord, there was a passing comment in the labor code reference that these are the workmen, my lord. But there was no adjudication done as to whether they come on.
That's fine, that's what I pointed.
Yes, absolutely. my lord.
That will not hold water.
Yes.
it is
You
in
need to
addition.
know that right now, because otherwise you will feel that.
No, my lord, it is in addition to the first. The three things. One is opportunity given, no pleadings, no evidence, not pleaded in the High Court also, ground for challenge of the award that it is lacking jurisdiction. This is one. Number two, there is earlier round, this happened. And my lord, we have in our evidence stated that I was not having any managerial or administrative functions. That has come on oath in an affidavit before the labor court, and that part was not cross-examined. So, my lord, though the initial burden is on them, onus is on them to prove that I am not a workman, they have not discharged that burden. On the contrary, I have come up with some statement that I was not having these functions, and I was not cross-examined, and that part of my evidence has gone unrebutted.
All right.
But that part of the evidence is referring to the staff regulation. These contains in para 2 that as per staff regulation, I am a staff, but which is contrary to the staff regulation.
Even the staff regulation is also not part of the labor code.
All right. So let us not turn into a
My lord.
jibing. So we'll close the matter, Mr. Chakraborty.
My
Close the matter, yes. I heard Mr. B. Kaushik, learned counsel appearing for the writ petition. I also heard Mr. S. Chakraborty, learned counsel representing the respondent number 5. Ms. A. Talukdar, learned government advocate Assam has appeared for respondent numbers 1 to 4. Arguments concluded, judgment reserved. Make it into a, make it into a file, and then I will get admission item 30, call it.
Highly obliged.
Yes.
My lord, I'm really sorry to
Mr.
hear.
Chaudhary, see, the point is, this trend has started happening.
So this is
we are in
really,
the-
this is something which should not be
It's
tolerated.
not that he has asked anything to be decided in a particular manner. That is not the case. You might have some genuine grievance. But what to do? The litigants have started sending SMSs to the judges directly. This is not the first time. But we need to deal with these matters. What
That's
is
why,
your
my lord,
suggestion?
My suggestion is that, my lord, this is interference with the, my lord, dispensation of justice. So far as I am concerned, my lord, in this case, I'll seek 1 week's time to file an application to withdraw from the case, seeking leave of the court to withdraw from the case. And I'll urge that your lordship will take, my lord, action so that, my lord, this become, my lord, known to everyone. So that the litigants do not, my lord, dare to do it.
No, see, there's nothing about you. It's
No, I understand, my lord, but at
You
the same time.
obviously don't have anything to do with this, but as a senior counsel, I am asking you, how are these matters to be dealt with? Because now we are going for transparency. People are seeing the proceedings every day. The particulars, numbers of judges are available. We are not hiding behind the. But at the same time, if these things starts happening,
My lord, the
And
clients
certainly-
thinking that my case has not been decided, there are plenty of, my lord, naturally clients think my case is the most important case, this has to be dealt with.
But your client is from which place?
This is from Tinsukia, my lord.
For now, we will just post it next week on your request,
My lord.
without saying anything.
My lord.
On the request of Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. Sharma, Learned Counsel appearing for the writ petitioner. Let this matter be listed again on 30th of May 2023 as a fixed item.
My lord.
Lordship will take up the list of dates first. From there, I'll just point out, so that will be easier in that case. So the first is that on 15/2/1989. Yes. The Writ petitioner was initially appointed, Your Lordship, as junior field officer in the rubber boat in on 15/2/1989. I'll just point out that has not been incorporated in the list of dates, that the respondent number 5 was appointed on 29/10/1993, 4 years later. It has been referred later on, but I'm just pointing it out. Then, Your Lordship, the first gradation list that was published was on 31/3/1994. In the gradation list, the petitioner was at serial number 29, Rosmi Rekha Mozumdar at serial number 31, and respondent number 5 is serial number 125. Here, Your Lordship, just for a moment, I have put the name Rosmi Rekha Mozumdar here, though she is not the petitioner in this case, to point out how it has supersession has been done at a stage. That is why I'm just giving it for a reference only. But the petitioner is Prasanto Borua, he is in 29. So Your Lordship will then take the writ petition was thereafter promoted to the post of field officer in 1996. At that point of time, the respondent number 5 was not promoted, Your Lordship. Then in 1998, the gradation list was published for the post of field officer. In field officer, the writ petitioner was at serial number 149 and the Rosmi Rekha Mozumdar is at 151. So both of them has already gone to the next post. In that post, the respondent number 5 has not yet been promoted at that point of time. So Your Lordship will kindly take up page 65. I'll just point out that's page 66. Relevant part, page 66 onwards. In page 66, Lordship will see the petitioner as field officer. His name is at serial number 149, which is at page 71. 71 page, his name is at 71.
Page 79.
71. 1. Petitioner at 149 serial number. Here I just point out one thing, Your Lordship. Here his appointment in 15 February 89 has also been shown as initial appointee. And then, Your Lordship, the next page, 72, Your Lordship will see this Rosmi Rekha Mozumdar's name is there, just below me. She was also appointed in 1st of March 89. So these two persons are normally nearby, very nearby, one below me. Now the respondent number 5 name is not there. So that part, as of now, he has not yet been promoted to the next post. Now Your Lordship will see. On 2/6/2006, the writ petitioner was promoted to the post of, I'm reading number 5, the post of Assistant Development Officer. So in 90, after being promoted to the post of Field Officer in 1996, after 10 years, in 2006, the writ petitioner is promoted to the post of Assistant Development Officer. And that, your lordship, the gradation list of 2006 was also published. That is on 31/12/2006, page 73, your lordship. Next page. Here, your lordship will see in the Assistant Development Officer, my name is the last one at page 77, Prashanta Borua, the last person in that said list. Here also, your lordship, I am seeing it. And the respondent number 5 have not yet been promoted to the Assistant Development Officer. So that list, gradation list was published. Here, interestingly, your lordship, I have also annexed the list of the field officer list here, along with this list, your lordship. That was published on the same day, that is 31/12/2006, at page 79. Same list, but this is the list of field officer. So I am already ADO. The respondent number 5 is as a field officer, and his name appears at serial number 80 in field officer at page 82. Your lordship. So therefore, he is not even incorporated in my cadre when I am promoted. He is also there in the next below cadre, and that too at serial number 80. And Rashmi Rekha is just at the top at serial number 1. So since he was below me, she is serial number 2. So there is no problem till here, your lordship. Now what has happened? Serial from the list of dates I am reading, 7. The respondent authorities did not hold any DPC in the year 2006, 2007, and 2008. At that point of time, 6 posts were vacant, 222.
Post in the ADO.
Yes, in the ADO. ADO were vacant at that point of time. I have already been promoted. That is because I am coming to this so that the initial problem starts from here. That is why I'm pointing it out along with the judgments. So in 2009, there were 20 vacancies in the ADO. So overall, there are 26 vacancies in these 4 years. Now, what they have done, they have clubbed the vacancies of 2006, 2007, 2008, and 2009, totaling 26 vacancies, and thereafter, they had the DPC. So this clubbing together is against their own rules. I'll just point out the rules.
It is against the Supreme Court judgment.
Yes, judgment is, I already, decent judgment. Okay, I'll provide the judgment. There are judgments that you cannot club together. Different year of promoting different year for promotion, clubbing together the different years for promotion. So that Supreme Court judgment, I will give the judgments. 3 judgments I have brought, so that is there. So they have done that. Because of that, what has happened? The clubbing together, if they take 2, 2, 2, and 20, in that case, the number of persons within the zone of consider would be very less. If you club them together, now it comes to 26. Now clubbing them together, it went to 100 and something. In that case, the persons who were much junior came up, and then they were given the promotion.
What was the criteria for promotion?
The criteria promotion is seniority come merit. That is not in dispute. There is no dispute with that. The only issue was that seniority. So what has happened? This is the starting of the problem where it started because of clubbing together. In clubbing together, what happened? These respondent, particular here I am on with regard to only this respondent. So this respondent was at serial number 80 in the list, came under the zone of consideration, and he was selected. Not only selected, he was given appointment above us. That I'll come. Now, your lordship will take up at serial number 10, I am coming. 4/12/2009, the order of promotion for the 26 vacancies for the period of 2006 to 2009 were given en bloc. Now, this is the reason I have brought in Rashmi Rekha Majumdar to show this is the reason how they have superseded. Now, your lordship will see at page 88 for a moment. 4/12/2009, the promotion, page 88. Now, they have given promotion clubbing together the vacancies. Page 88 for a moment.
Yes.
This is to the ADO. This is the order of promotion, where your lordship will see D. Suresh, the respondent number 5, who was at serial number 80. Now he is number 8 here in the list. Number 8, D. Suresh. Now your lordship will interestingly see the name of Rashmi Rekha Majumdar is at serial number 20. This is the reason I brought the reference of Rashmi Rekha Majumdar. Actually, Rashmi Rekha Majumdar is at serial number 3 in the field officer list.
Where is serial number 20? In which page?
Next page 89. 88 and 89. 88 D. Suresh at serial number 8 and Rashmi Rekha as serial number. Now, what they have done from here, I would like to point out. What they did, they brought all the SCSCs above, putting them that in the quota system, the reservation rooster point, because they are in the higher in the rooster point, all these persons were put above Rashmi Rekha Majumdar. I am not affected as of now till date, but this was done at the initial stage where they went wrong. Now, your lordship, the next promotion, I am affected. That is now that part comes. Now, your lordship will turn to serial 11 of my list of dates, 2014. From here, the issue starts. In 2014, again, DPC was held for 6 vacancies of 2012, 12 vacancies for 2013, and 6 vacancies for 2014, all clubbed together again, and coming to 24, altogether 24 vacancies for the post of ADO. Now, sorry, DO, there is now development office. In this case, you'll see what has happened after the promotion, last promotion, there was no gradation list was published. In serial number 10, I have stated last line, no gradation list was published after the promotion. In fact, no gradation list was published from that 2006 till 2021. All the promotions are affected without there being any gradation list. And in this was the reason the petitioners were in fact in the dark where they stand in the gradation list, where their seniority, whether they are senior or not. Therefore, what has happened after these 24 vacancies of the DPC conducted, serial number 12/8/2014, promotion to the post of development officer was issued from the post of ADO. There was no gradation list after 2006 in the cadre of ADO. The writ petitioner was so far cadre senior to the respondent 5 was not promoted. So at that time, I was not promoted, your lordship. So I filed the writ petition challenging that. I'm not coming on that because that's separate writ petition, nothing to do with this case. Now, your lordship, the next 29/10/2014. 29/10/2014, what has happened, your lordship? One new promoted incumbent in the cadre of DO expired, and in the vacant post, D. Suresh, the present respondent number 5, was promoted as development officer without holding any supplementary DPC in violation of the rules. So this is the order that is, your lordship will find at page 113. Lordship will kindly take up. This is under challenge in the writ petition, earlier writ petition. Yes. This is the office memorandum. I'll just read this. D. Suresh, Assistant Development Officer, Mangalore, is provisionally promoted to the post of Development Officer in the pay band so-and-so with grade pay so-and-so in the existing SC reservation vacancy. He is transferred and posted to Itanagar, Arunachal Pradesh for opening new regional office at Itanagar. On relief, he should report for duty before the additional RPC, ZO Guwahati for further instructions. The promotion order will have effect only from the date on which D. Suresh assumes duty in the promoted post at the place of posting and will not confer any right or claim other than the emoluments attached to the post. He may refer to the office order so-and-so and office circular so and so regarding fixation of pay on promotion and exercise option within the stipulated time. I'll not read the rest. This was the order passed, he was promoted. We have challenged it. The present petitioner challenged it. And the next page is the order, that is page 114 of this honorable court, interim order. Interim order, cooperative part at page 116. Till then, status quo existing on today shall be maintained in respect of promotion of respondent number 13. Here respondent number 13 was the present respondent number 5. So there was a status quo order, and I would like to point out here that due to this status quo order, the respondent number 5 did not join in the next post. So he remained to the earlier post as it is.
Edio.
He remained. He could not join as development officer. Now, what has happened? There were many cases, one with regard to the earlier selection of 2009, and there was a selection of 2014 with regard to promotion part. So those were challenged. All the matters were taken together along with this case of the Suresh promotion. And this honorable court in the next page, page 117, gave the judgment. In the judgment, the 117, I'll just read the operative part.
Operative, no, we would like to read this judgment.
Yes, judgment has three parts. That is why it will confuse your lordship. That is why I point out
Give that to me. Don't worry about confusion. You place what.
the whole judgment I'll read,
Yes.
or the part which
No, no,
concerned with this case.
No, whole judgment.
Okay. The whole judgment actually is under challenge before the division bench, your lordship. So I'll read from
This judgment dated 23/3/2021 is
21.
under challenge.
Yes, this is under challenge.
Read appeal is still pending.
Yes, challenge with regard to the first 2 points, not D Suresh. D Suresh is already attained finality because it was his selection was set aside, promotion was set aside, and that he did not challenge that. So that remained. The rest three writ petitions by Rashmi Rekha Majumdar and one by Prasanta Borua with regard to the earlier promotions were dismissed by this honorable court, and that is under challenge before the division bench.
So this judgment dated 23/3/2021 decided and disposed of how many writ petitions?
4.
Okay, so
So
one
out
of
of
them,
these 4,
let's just a minute. One of them was writ petition challenging the order of promotion dated 29/10/2014
yes,
of the respondent number 5.
yes.
Who had challenged this order? Who are the petitioners?
This petitioner, particular present petitioner
Present
challenge
petitioner, he has challenged.
yes,
This is one writ petition.
one writ.
Can you give me the number of that?
Yes, that writ petition number 5815 / 2014. So your lordship will kindly take up page 124.
Just a minute.
Yes. As I'll specifically pinpoint that particular judgment of a particular case of.
Mr. Manan, you don't appear to be correct.
Yes.
There was another petitioner in 5815. Not your client alone.
5815. Prasanto Borua is the petitioner, and there was another petitioner who is Pradip Kumar Goswami, who is already retired. So he is not here.
No, but
So I
then
am the
it-
only
It
petitioner
was
now.
not the,
As of now.
that time it was filed by two writ
Two
petitioners.
petitioners.
You are saying one.
I am one of them. Prasanto Borua is there and Pradip Kumar Goswami was there. Pradip Kumar Goswami is retired.
Hmm.
5815, there was an interim order passed. And finally, your lordship, there are 4 writ petitions, 7777 of 2016. 5815 I have already stated, then 3717 of 2016 and 6901 of 2014. These are the 3 other writ petitions which were taken together by the honorable court.
What is the challenge in 77?
The 777 is by Rashmi Rekha Majumdar. This was with regard to the again, what I have shown your lordship, this she was superseded by various other respondents who are not a part of this writ petition. So she has challenged those promotions with regard to the other respondents who have superseded her.
All right, what is WPC number? There is another.
One of the writ petition by Prasanta Burua. That 5815 and
3717.
3717 is also by Rasmi Rekha Muzumdar. This is with regard to the subsequent promotion to the post of DO. No.
That is order dated 29/10/2014.
No, that is 12/8/2014, because the others were promoted in 12/8. 29/8, only this petitioner was promoted. The last one, 6914/2014 is also with regard to 12/8/2014. These two are on the same footing.
Yes, and then another writ petition is
The 6901/2014. This is also by Rasmi Rekha Muzumdar. Again, on the same point of supersession. I think it is with relative selection of 2009. The selection of 2009. This was subsequently. There was some delay in that because of the non-publication of the gradation list. So it was challenged in 2014. Now your lordship will see at page 126, para 4. This is with regard to presently this petition. That is why I am going into.
Then you please take your seat. Let me finish reading the judgment.
Whole
Without
judgment.
reading the whole judgment, I will not.
No, I'll
proceed
read the
in-
whole judgment.
Then
That's not a
read.
problem. I'll read the whole.
Read.
From para 2, I am reading you. So the petitioner here.
You may be right. The other part may not be relevant, but I need to know what was the entire
I'll just.
spectrum. Yes.
I'll read from para 2, your lordship.
Yes.
The petitioners herein have challenged the legality of the action taken on part of the respondent to promote the private respondent in these 4 writ petitions. The petitioner in these 4 writ petitions claim to be senior to the private respondents. The case projected in the writ petition is that the petitioners were appointed as field officer at various point of time, and they have become eligible for promotion to the next higher grade of assistant development officer, in short, ADO. The private respondent and others who were junior to the petitioners were promoted and en bloc placed above the petitioners. Accordingly, it is projected the petitioner is deprived of being considered for promotion to the post of development officer from the post of ADO. It is projected that the respondent number 1 is as an employer published the gradation list of employees on 31/3/94 and thereafter on 31/12/98. Thereafter, the gradation list of employees was published on 31/12/2006. It is submitted that between 31/12/98 and 31/12/2006, no gradation list was published. The grievance of the petitioner is that the respondent authorities did not convene any DPC meeting from June 2006 to November 2009. And during this period, 26 vacancies arose in the rank of ADO. Referring to the statements made in affidavit in reply filed in WPC number so and so, it is projected that in the year 2012, total 6 vacancies were fixed. In the year 2013, 12 vacancies in total were there. The grievance of the petitioner is that according to the relevant circular of the Department of Personnel 10 March 89, bearing so and so, the DPC is required to consider year-wise vacancies position. However, in the present case in hand, the DPC has considered vacancies which arose in 2012, 2013, 2014, and thereby the zone of consideration was extended and larger number of reserved category candidates who were junior to the petitioners were considered for promotion. The petitioner in WPC 5815/2014 have made the calculation to project that the 6 vacancies for the year 2012 was inclusive of 2 vacancies for SC and 4 vacancies for SC, and therefore it has been projected as no more SC or ST candidates in the consideration zone. 4 posts was to be filled up with general candidates in order of seniority. It is projected that for the year 2012, as both backlog vacancies of SC was filled up, there was no backlog or SC and there was only 4 backlog for ST candidates. Similarly, for the year 2013, it is projected that out of the 12 vacancies, only 1 candidate was for ST candidate, which fell within the consideration zone, and no SC candidate would fall on that zone. Accordingly, it is projected that 9 vacancies could be filled up for general category candidates, 2 of the SC and 1 ST candidates, and resultantly, as 1 ST post was filled up, the backlog position would be 2 for SC, 3 for ST, and 1 for general shortfall. And therefore, the vacancy position was required to be filled up and was required to be kept as backlog vacancies. In connection with the year 2014, it is projected that out of 6 fresh vacancies, 5 was for general, 1 for SC, and none for ST candidates, and the backlog vacancies would be 2 for SC, 4 for ST, and therefore, as no SC/ST came within the zone of consideration, 5 posts were to be filled with general category, and 1 post was required to be kept as vacant. Therefore, it is projected that after promotions to the post of DO in the year 2014, the position of backlog vacancy would be 4 for ST, 2 for SC in 2013, and there will be a shortfall of 1 post for the year 2014, where all the posts already kept vacant. This is that number 4. That Learned Counsel for the petitioners has submitted that WPC 5815/2014 was filed when the private respondent therein, namely D. Suresh, ADO, was promoted to the post of DO, and accordingly the petitioners in the said writ petition has approached for setting aside the office memorandum dated 12/8/2014 for promoting the private respondent number 5 to 13, and the petitioners had also prayed for quashing the OM dated 29/10/2014, promoting respondent number 13 to the rank of DO with all consequential benefits. The petitioner had also prayed for considering the case of the petitioners for promotion to the rank of DO in accordance with their position in the gradation list of 31/12/2006, published by OM dated 27/2/2008. Thereafter, WPC 6901/2014 was filed with a prayer for setting aside the impugned OM dated 4/12/2009, by which private respondent number 4 to 24 were promoted to the rank of ADO with all consequential benefits, for setting aside the impugned OM dated 12/8/2014 and also impugned OM dated 29/10/2014 referred to above, and for a direction to the respondent authorities to place the petitioners above the private respondents in the seniority list of ADO. The petitioners has also prayed for directing the respondent authorities to review the representation of reserved category persons basing on quantifiable data in the cadre of ADO and DO, and to grant further promotion on the rank with all consequential benefits. Petitioners in WPC 6901/2014 had filed WPC 3717/2016 with a prayer for setting aside the impugned order of OM dated 14/6/2016, by which private respondents number 4 and 5 were promoted to the rank of ADO with all consequential benefits, and for a direction to the respondent authorities to place the petitioner above the private respondents number 4 and 5 in the seniority list of ADO. The same petitioners have approached this court again by filing WPC 7777 for setting aside the impugned order dated 16/12/2016, by which private respondent number 4 was promoted to the rank of DO with all consequential benefit, with a further direction to the respondent authorities to place the petitioner above the private respondent 4 in the seniority list of ADO. The Learned Counsel for the petitioner has referred to the OM on reservation of ST, SC, and other backward classes in service issued by the Department of Personnel Training, which is annexed to WPC 477 as Annexure 4, and OM dated 10/3/1989, OM dated 31/2015, and OM dated 6/1/2006, which contains guidelines for DPC and procedure to be adopted in conduct of DPC. Instead of quoting the said OM, it would suffice to mention that as per the submissions made by the Learned Counsel for petitioner, that the DPC should consider nearby vacancies, and that if any vacancies arose for the last DPC, it was required that supplementary DPC shall be constituted for making selection. It is also submitted that without the gradation list being finalized, the DPC should not have considered the promotion of various candidates to the promotional post of ADO and DO. Reference is also made to the procedure of DPC as per OM dated 10/3/89, and it is submitted that vacancies of various groups and periods cannot be clubbed together. Referring to various gradation lists on record, the learned counsel for the petitioner has projected that various persons promoted in the post of ADO and DO superseding the petitioners herein are not even born in the gradation list on record, being gradation list 1998, 2006, and 2009. Explaining the cause of delay in challenging the promotion granted to the private respondents, the learned counsel for the petitioner has submitted that it is only when promotions were made in the year 2014 that the petitioners became aware of them being superseded, and therefore the writ petitions were filed as and when they found themselves aggrieved by the promotion of the private respondents pleaded in these 4 writ petitions. The learned counsel for the petitioners in his written note has referred to 13 case citations apart from quoting a part of one of the said case in his written note. However, recital of relevant passages of none of the cases were actually referred before this court. In this connection, it is observed that in one of these writ petition references made to pendency of WPC number 577113 and 684113 before the High Court of Kerala. A copy of the common judgment of 5771/2013 and WPC so-and-so along with WPC 1127/2015 have been downloaded by this court. On perusal of the said common judgment dated so-and-so, it does not appear that DPC of the promotion which is under challenge in these 4 writ petitions was a subject matter of adjudication before the High Court of Kerala. In the said judgment, reference is made to section 25(2) so-and-so of the Rubber Board Act 1947 and the Rubber Board Service Rules has been referred. The said order shall be dealt with at a subsequent stage. Par contra, the learned senior counsel for the respondent has made a short submission to the effect that the other promotion which has been put to challenge in these 4 writ petitions are all fallout of the DPC meeting held on 21/7/2014. It is submitted that the minutes of the DPC has not been put to challenge in any of the 4 writ petitions. It is also submitted that the petitioner is of general category and the private respondents impleaded in the 4 writ petitions are of the reserved category. In this regard, it is submitted that the petitioners who belong to the unreserved class could not have challenged the promotion of SC category persons. Referring to the rejoinder of affidavit filed in WPC so-and-so, it is submitted that not only there was vacancies which was considered, but the position of the petitioner in WPC number so-and-so was at serial number 86 of the general category, and the said petitioner was not found eligible. As such, case of the said writ petitions was not considered. It is further submitted that the prayer made in the 4 writ petitions insofar as it is relates to placing the petitioners above the private respondent is concerned, the same would have the effect of disturbing the seniority position of all those whose name appeared after the private respondents. In this connection, it is submitted that without assailing the DPC minutes of 21/7/2014 and without any challenge to the impugned OM dated 4/12/2009 in 3 writ petitions except in WPC 6901/2014. The relief prayed for by the petitioners in the other writ petitions cannot be considered by this court. In respect of the challenge made in OM number 4/12/2009 in 6909/2014, the learned senior counsel of the respondent has referred to the case of so-and-so, AR 74 SC 2271, 75-1 SCC 152, wherein the Supreme Court of India has.
All right. So now you can come to para 12. That is where the finding of the court. Yes.
There is no dispute at the bar. That DPC is the authority competent to take into consideration the applicable rules in force governing the entitlement to promotion from amongst the list of persons who are considered eligible to be considered for promotion to the next higher promotional post. The learned counsel for the petitioner has made his meticulously submissions on the manner in which the DPC is required to consider cases of reserved category candidates for promotion of quota earmarked for reserved category. He has taken pains to explain the distinction between shortfall of reservation and number of backlog reserve vacancies in the cadre. It was done to stress on the point that as the vacancy position for 3 years was considered by DPC together without taking into account the year-wise vacancy. However, by taking into consideration that the cadre strength of the post of ADO was 107, nonetheless, in all the 4 writ petitions, the minute of DPC meeting held on 21/7/2014 has not been challenged. Therefore, the challenge to the consequential OM dated 12/8/2014 and 29/10/2004 impugned in WPC number so-and-so and OM dated 16/12/2016 impugned in WPC number so-and-so, which are fallout of the DPC minutes dated 21/7/2014 is held to be not maintainable on facts and in law. Similarly, the minutes of DPC meeting held on 4/12/2009 was not challenged in WPC number 5815/2014, 7777/2016 and 3717/2016. Therefore, the challenge of consequential OM dated 14/6/2016 is held to be not maintainable. The minutes of the DPC meeting held on 4/12/2009 has been challenged in WPC 6901/2014. However, guided by the ratio laid down in the case of so-and-so, as followed by this court in the case of Mridul Chandra Das versus State of Assam, decided in so-and-so, the belated challenge is held to be not sustainable on the facts and in law, because by this time benefits has accrued to several persons, and in this regard, para 2 of the said cited case of so-and-so is reproduced below. I'm not reading the cited case. There are 13. It may be mentioned that although the learned counsel for the petitioners has strenuously argued that in order to have an effective DPC, the gradation list has to be prepared annually, but to that effect, no prayer has been made in these 4 writ petitions. Moreover, in these writ petitions, prayer has been made for direction to the respondent authorities to place the petitioners above the private respondents, which cannot be granted because by directing the respondent authorities to place the petitioners above the private respondents, the seriatim of the persons placed after the private respondents and those whose names appear before the petitioner would have to be altered. However, persons who are likely to be affected by such exercise have not been made a party respondent in this writ petition. Hence, the relief for directing the respondents to place the petitioners above the private respondents is hid by the principle of non-joinder of necessary parties. Under the facts of the present case, the cases cited by the learned counsel for the petitioner are not applicable because of distinguishable facts. It is seen that in WPC number so-and-so, the petitioner had made reference to the interim order passed by the High Court of Kerala. However, a copy of common judgment and order dated so-and-so passed by the High Court of Kerala was downloaded by this court and perused. However, from the facts narrated therein, the learned counsel for the petitioner could not show if any gradation list, DPC, OMs or orders impugned in these writ petitions had been examined by the said honorable court. Thus, the learned counsel for the petitioner could not show the relevancy of the said case cited by him. Therefore, in view of the discussions, challenges made in WPC numbers 7777, 6901, 3717 fails, and the said writ petitions are dismissed. 17. In connection with, this is our case, with WPC number 5815, the respondent number 1 to 3, Rubber Board has not been able to show that in order to promote the private respondent number 13, namely D. Suresh, any DPC or supplementary DPC was held. Hence, the challenge to the promotion of respondent 13, WPC so-and-so, is sustained. And as such, the impugned OM number so-and-so dated 29/10/2014 in respect of the respondent number 13 herein is set aside, making the interim order dated 14/11/2014 passed in WPC number 5815/2014 absolute. The other prayers made in the writ petition stands refused. So this is
in terms of this order now, they have gone on to give him promotion, but with retrospective effect.
Now, that is
Now.
later. At that time, it has been set aside. So once it is set aside, we come to the main part where I am challenging now. Now they have, after the order, the judgment was passed, I am promoted. I am also promoted, but prior to him. Now I am in the development officer category. Then after the judgment, he's also been promoted to the development officer category, but he was put much above me at serial number 3. I am at 20. Your Lordship,
So that is
now in this case.
We'll continue.
Yes. So that part I will come now.
We'll sit at 2:10 because there's some meeting today with the bar. At 2:10.
Yes, 2:10.
2:10. We'll continue.
My lord, urgency is that lordship. In this case, I have challenged one selection list lordship, whereby lordship, the MBI, some post of MBIs are hereby directed to be appointed lordship, and I am one of the candidate lordship for the said post lordship. And after doubting the selection process lordship, when I file an RTI lordship.
What do you want?
Lordship for listing lordship for tomorrow.
When?
For tomorrow lordship.
Yes.
Lordship.
Happy?
Lordship. Obliged lordship.
Yes.
Lordship, item number 18, Lordship, I'm sorry, I was not there when the matter was called up. Lordship, my partnered matter is going on in court number 1. If I can reply tomorrow, first item tomorrow, Lordship.
Do it day after tomorrow then. Day after tomorrow.
Lordship, on the top of the list, Lordship.
Day after tomorrow. Or Mr. Edad Gupta, senior counsel appearing for the applicant writ petitioner on the request of Mr. R.K.B. Chaudhary, DSGI, list this case again on, give the date at the top of the list
Lordship,
as a fixed item.
always Lordship.
Yes.
So your lordship, after the order passed for him against the judgment of this honorable court, setting aside his promotion, then what has happened? Your lordship again take up the my list of
So
dates.
only one writ petition was allowed, that is 5814.
This
or
particular writ petition, this is the one which has been allowed. And after allowing this writ petition, it was set aside. Now thereafter, what they have done?
The
your lordship,
allowed means partly allowed.
partly allowed with regard to his setting aside his selection.
On the ground that it was done without holding any DPC.
Yes, yes, yes. So that is the ground. Whatever ground it is, regarding the other grounds, I'm not going to argue because that is before the division bench. Whatever judgment has been passed by the honorable single judge, I'm not going to discuss about that. So only with regard to this, I'm saying that this was set aside, being there is no DPC, supplementary DPC held. So it is bad in law, it was set aside. That is gone. Now what has happened subsequent to that, after that order, I was promoted. So I was promoted to the post of DO on 6/5/2021.
You call it.
I was promoted, the order judgment of this honorable court was on 23.
When I call you, send Chaudhary. Send Chaudhary for the dictation of the judgment.
Judgment of this honorable court was passed on 23/3/2021. Then I was promoted thereafter, 6/5/2021, I was promoted. On 1/7/2021, that point just lordship will see at
Just
serial.
1 minute. You were promoted, what did you say? You were,
That point,
after the judgment, what happened?
after the judgment on 23/3/2021 judgment passed. The next is on 6/5/2021. That is not stated in the list of dates. I'll just point it out. 6/5/2021. I am promoted to the post of development officer. The petition.
Yes.
Then what happened? After about 2 months, on 1/7/2021, serial number 15 of my list, 1/7/2021, respondent number 5 promoted to the post of development officer. So he was promoted after 2 months after me to the post of development officer. On the same day, Rasmi Rekha Mazumdar was also promoted to this. Now what has happened? 1/11/2021 is under challenge before this honorable court, the order of promotion. He has been given the retrospective seniority, which your lordship will find at page
134.
134. This order is under challenge before this honorable court. Here two things are very clear. One is that it was on the basis of a representation filed by D. Suresh on 26/4/2021. He requested to restore his seniority based on his earlier promotion, order dated 29/10/2014 as per the judgment dated 23/3/2021 of the Honorable Court of Guwahati. He was promoted to the post of development officer in vacancy OM dated 29/10/2014 based on his select list of DPC held on 21/7/2014. But due to the stay order of 14/11/2014 of the Honorable Guwahati High Court, so D. Suresh was unable to join duty in the promoted post of DO. Later on, by OM dated 1/7/2021, D. Suresh was promoted to the post of development officer in SC reservation vacancy, but not reinstated his previous seniority. Now, a review DPC was convened and the committee examined the case in detail. The committee recommended to reinstate the seniority of Sri D. Suresh to the post of development officer as the seniority list of DPC held on 21/7/2014, by which he was promoted as development officer. Accordingly, the seniority of D. Suresh in the post of development officer is reinstated with effect from 14/11/2014, the date of interim order of the Honorable High Court of Guwahati in WPC number so and so for maintaining the existing status quo and his position is placed between so and so as per the then
So
existing.
you are
seniority.
only aggrieved by the retrospective
Yes.
effect to the seniority.
I'm agree because otherwise I am senior. I was promoted earlier to him. Now, when I'm promoted to the ADO earlier to him, he was promoted 2 months later to me. Now he has been given the seniority. That is, your lordship will see in the next page, page 135. This is the gradation list of employees on 31/12/2021. Here your lordship will see D Suresh at serial number 2. The respondent number 5. Here his date of promotion is shown at the 14/11/2014 in the column 1, 2, 3, 4, 5, 6, 7. It is shown like that. And your lordship will find me at 136, serial number 24, Prasanto Borua, where I have been shown to have been promoted. Next page, Prasanto Borua, 24, serial number.
So 24 is okay, but you are aggrieved by number 2.
Yes, how he has gone beyond me because I was promoted 2 months earlier to him. And earlier promotion was set aside by this honorable court. There's no question of going back to the, you cannot go back to the earlier promotion. And in that case, I will also have some judgments because you cannot be retrospectively promoted.
Where does the executive director sit? Where is his office?
Kerala.
He has to come and personally appear. We'll draw up contempt against him.
But
How could he, once the court has set aside the promotion notification of 29/2014, how could he hold a DPC in the year 2021 and give effect to promotion?
the proceeding of the review DPC, I am having a copy. Milord.
No, where is the question of review? There was no DPC.
No, in fact, it was, Milord, Milord, kindly take up our affidavit. Milord, the reason for setting aside the promotion given to this race was that without holding any DPC or any supplementary DPC, he was promoted.
Right.
But in fact, in the year 2014, when the promotion order was issued, 3 months back, in fact, the promotions were given. The person who was promoted 3 months back, he died in the meantime. The authority at that point of time thought that since the DPC in that particular DPC, which was for giving promotion 3 months back, in that DPC, the B Suresh was also there and he was found fit for promotion, but because of he was within the zone of consideration, but because there was no vacancy, the person, he was not promoted and the other person was, senior person was promoted. That senior person, he died after 3 months. The authority thought that since he was considered in that particular DPC and found fit, and the person died, a vacancy arose.
No, whatever he thought, we are not concerned.
Logic.
Are you defending this order, giving retrospective effect from 2014?
Malad-
What is your stand?
Malad,
You tell us, then accordingly we'll see.
Well, the review DPC, I'm just pressing the, because I cannot go beyond the records. In fact,
No,
in fact,
Mr. Nath,
Logic.
you are appearing for the executive director.
yes, yes,
The court is asking you very clearly
Logic.
that, of course, these are all debates in the realm of legal principles.
Yes,
There is an assumption that all of us have some preliminary idea of the legal principles.
correct.
The promotion given to him in 2014 was found to be illegal. It was set aside.
No, Malad, various grounds were taken. Lordship has seen.
Oh, please come to page 132, Mr. Nath.
Yes, Malad.
What is the finding of the single judge?
Because Malad,
Please read para 17.
Para 17, in connection with WPC number 5815/2014, the respondent number 123 rubber board has not been able to show that in order to promote the private respondent number 13, namely D Suresh, any DPC or supplementary DPC was held. Hence, the challenge to the promotion of respondent number 13 in WPC number 313717 of 2016 is sustained. And as such, the impugned OM number so and so dated 29/10/2014 in respect of respondent number 13, therein is set aside by making the interim order dated so and so
So
absolute.
his promotion goes, interim order becomes absolute.
Logic.
You again do something, setting him at the same position before the interim order. Is it not contumacious?
Malad,
That means the order of the single judge comes to a naught. he gets promoted with effect from the same date, which the learned single judge says he could not have been done.
Because the DPC or supplementary DPC was not.
Give us the
that-
name of the executive director,
Matlab-
we'll issue contempt notice to him.
Well,
When you complete your argument, but also give the name because this is the order I am going to pass. Personal appearance. We are not sitting here, cracking jokes. The learned judge clearly says this order of promotion given on 29/10/2014 is illegal. It is set aside. The interim order by means of which the order was suspended, status quo was directed, is made absolute. Then in 2021, he is promoted and given seniority from 2014. How can you give seniority to a person in a cadre on which he was born in 2021? Are these not blatant attempts to override the court's order?
Look-
If we allow these things to go, then there will be no end to litigation. So you argue, but please give me the name of the
No,
respondent.
no, Matlab, I,
No,
I,
we'll direct it.
I
We'll
got the,
see what
no,
happens.
I got the, Matlab, I'll definitely take it, Matlab. But just I'm, since the review DPC, my notes I got, Matlab, just the paragraph. The reject.
Whatever
I'm
be
not
the
just
review
listening.
DPG, Mr. Nath, the
Gotcha.
question is, we are coming back to the same point.
Correct.
You also know you can't push this court to take a view which is not in accordance with law.
Gotcha.
The fact of the matter is that this man was promoted earlier, 2014. The learned single judges set aside his promotion by holding that it was an illegal process. Correct,
Lordship. Without holding the DPC, he was
right.
lodged.
So, though no liberty was also granted for anything, but let us presume that since the ground is that no DPC was held, now the DPC could have been held. He could have been promoted, there is no problem. But how do you give retrospective effect to that? With effect from 2014. Is that not a mockery of the court's order? Is it not a mockery of the court's order? And do you expect the judges to keep looking at people making mockery of court's order?
No, absolutely
Then
not.
what is the other option? Tell me. You tell me what is the other option.
Matlab,
We set aside, he will again do something like that. So we want
No,
the
that-
name of that person,
will-
the
that will not be-
executive director who had passed this order, that person. We will draw proceeding against him. Because we are not sitting here to keep repeating the same work again and again and again. See the respect they have a battery of lawyers. Who has advised him to pass this order? We are not concerned. He has passed it, he will have to face the movement. You argue, but by the time you conclude the argument, I want your junior to give me the name of the officer or the director who has passed this order.
No, Matlab, in view of that position, Matlab, I'll because my argument is that only, Matlab, in fact, it is, I am placing what is in the DPC.
That's
only,
correct.
And since Lordship has expressed, Matlab, Lordship, we'll do the needful, Matlab. Lordship,
No, what else? You tell me, Mr. Nath.
Lordship.
What else is the view that is possible? If these things go on, then courts will pass orders. The officers will overturn it. Courts will pass orders. Officers will overturn it.
My respectful submission is not that it is not in their mind that they will overreach. Under the circumstances.
What else is this?
Under the circumstances they have explained, Matlab, of course, Matlab, Lordship will.
If you
Lordship will
want to
see-
defend, then you argue. I'm
No,
willing
Lordship
to
will,
hear you.
Lordship will definitely, Matlab,
But
ultimately,
then
if Lordship finds
these
that it
things
is
are
wrong-
very glaring on the face of the record. The learned single judges set aside the promotion, made the interim order absolute. That means with effect from that day in 2014 till the judgment is passed, everything is wiped off insofar as the promotion of this man is concerned. You give him promotion, understandable. You give him seniority.
No, in
Imagine
fact-
this
correct,
situation.
Correct.
Let me
Matlab,
give you an
Matlab, I
Let
have-
me give you an instance.
Matlab, I have.
You are
also-
today holding an office, some office.
Lordship.
You are appointed in what, 2022,
Lordship.
with effect from 2015. And that too, when the court says the 2015 affair was illegal. Mr. Nath, I cannot
Correct.
do anything else but
Matlab,
initiate contempt proceeding against this
Matlab,
man.
I just.
I'm not writing any judgment on the merit.
Lordship.
These are not matters. We have other things to look into. This can't be done. What you want to do, you tell me. There is no problem. You are a counsel. You are free to make your arguments.
No, my lord.
But I'm making it very clear to you that this is a blatant overreach of the High Court's order.
But I'll definitely take care of the entire thing, Lord. I got the message, Lord. Lordship may give me 1 day time. 1 day time. Because the minutes, Lord, I spoke to them because the person, the petitioner hearing, he was promoted. I'm not, Lord, I'm not defending, since Lordship has expressed that they have, their action is contemptuous. I'm
Because
not
you see,
defending.
if
Just
I am
looking
to
at-
write out a judgment,
Lordship.
then I will write on all these things. I will write out. If the respondents want the court to deliver a judgment,
Lordship.
there is no difficulty. We'll write out a judgment. But then these things will crop up in the judgment. These things will crop up in the judgment because it is staring on the face of the record. What will you argue? That he could have been promoted then. If there was a DPC, then he could have been promoted. But for some reason, the DPC was not held. So therefore, that was a technical glitch which you have rectified in 2021. So this DPC will tantamount to DPC in 2014. That will be your argument, no?
They have.
What else? What other argument can you give? That is a
what-
preposterous argument.
That is, Lordship.
Absolutely preposterous argument. Earlier process was interdicted, it is over, and you should have got a clarification. How can you use reservation for fixing seniority?
No.
Law is well settled.
No, this is not a case, my lord, that I have examined, my lord. Here, my lord, the seniority is not on the basis of the roster, my lord.
Then what else? What else? This is complete lawlessness.
No. The Lordship may give me, I'll take care of it.
So what do you want to do?
I need 1 day time. I'll take up the matter with the executive director. I'll come back, my lord.
Let him see what he wants to do.
Lordship.
That he can always say, that is up to him. With regard to my case, I have already projected my case.
Mr. Manan, you should not have and do not have anything more to open your mouth.
Yes, I am not making any other submission.
Let him
Yeah,
get his
let him
instruction.
make whatever he wants to say, maybe 1 day.
As regard, Lordship, we're at a different point now. So, arguing about the selection of 2009, 2014, all these things, my lord, these were raised in the writ petition. It was dismissed, and the appeal is pending. So, other challenges, my
No,
lord.
other challenges are not
Lordship.
available.
Myself said I am not making any submissions on the other side, but I have said before this on the court.
Other things, he has already made it clear that those are heard together, but the issues were not exactly the same.
Yes.
Here the question was, but then I don't know.
The case.
This lady, Rashmi Rekha Majumdar, has also challenged the promotion given to the respondent number 5 here in one of her writ petitions, is
Yes,
it not?
yes.
Then that prayer is also allowed in this, by this order. Same prayer, both of them had made. Rashmi Rekha has also challenged the promotion given to respondent number 5.
Rashmi.
I think it was with regard to a bunch of cases.
Other-
of that
other
2014 other cases.
It is as regard the other person.
Other persons who are the respondent in the other.
Who is appearing for respondent number 5 here?
Mr.
Who is the
Abbas
counsel?
Abdur Rabba was appearing. We informed him, what can I say?
Private respondent is not.
See, the question is, you can argue, but then the argument that you are trying to project. Morning shows the day. This argument cannot be sustained. So it is not only a question of whether the order is legal or illegal. Obviously, it is prima facie it is an illegal order. But the question is, how could the officers at that level pass this kind of orders just to nullify the effect of the High Court order?
Well, I can submit it. That is not the intention, Milan. In fact, on 1st of July, he was given promotion, and thereafter he, along with the other person, they gave representation. And after that, the review DPC have considered and they have done. So I'm not just explaining the circumstances, Milan, under which.
Achha, you want to submit something, you argue? You
No, no,
want to
I have
please-
already taken, I have already submitted. Milan,
What
some-
is there you want to submit on review DPC? Please call someone.
But that I have prayed for some time. Milan. Let me.
That's all right, but you wanted to submit something.
I have
on
given the proceeding of the review DPC. Milan. That proceeding
Okay.
is there. Milan.
Where is the proceeding? Has it been given?
I have handed over three-page document. I have received in email. Milan.
Achha. Oh, yes, it is there.
Got
Yes.
it. But pursuant to this, 111 has been issued. The proceeding of the review DPC for reinstating the seniority of D. Suresh and Vasala Mathakal development officers. The judgment dated 12/8/2021 in WPC number so and so of the
You're reading from the first page.
first page. The relevant is kindly come to relevant is page second, first, second, third, fourth, fifth para.
Yes.
On perusal of the records, it is found that the DPC dated 21/7/2014 SSD APARS of preceding 5 years service records, general performance and suitability of Sri D. Suresh to hold the higher post and found fit. Even if separate DPC was conducted, the same candidate Sri D. Suresh was the next eligible SC candidate to be considered for promotion. Therefore, the committees of the view that the suitability of Sri D. Suresh was assessed by the then DPC dated 21/7/2014 and found him fit at a time itself, and hence there is no bar for promoting him by reinstating the seniority in the post of development officer. Accordingly, the seniority of D. Suresh in the post of development officer is reinstated with effect from 14/11/2014. That is the date of interim order of the Honorable High Court of Guwahati in WPC number 5815 of 2014 for maintaining the existing status quo. And his position is placed between so and so, Parasuram Nayak and Jyotsna Nair as per the then existing seniority list. In respect of Vasala Mathukul, was earlier promoted as DO by OM dated 14/6/2016, but not able to join the promotion post. Similar treatment has been given to her also. She is at the serial number 3 in the gradation list of 31st of December 2021. The stay order, as all the cases filed challenging her promotion was dismissed, the committees of the view that there is no bar in reinstating the seniority of Srimati Vasala Mathukal in the post of development officer. Accordingly, the seniority of Srimati Vasala Mathukal is reinstated with effect from 26/2016. That is the date of the stay order of the Honorable High Court of Guwahati in WPC number 3717 of 2016, and her position is placed between CR Omana and S. Nelson as per the then existing seniority list. That is
So how can it be done once the order is set aside? How can the seniority be reinstated on the date of the, if the order was maintained, then it is another thing. That the order is sustained. So therefore now give him the benefit of the order which is sustained. One can understand that. The order is set aside, then also give him the benefit from the date of the order. I heard Mr. Y.S. Manna, Learned Counsel appearing for the writ petition. I also heard Mr. D. Nath, Learned Counsel representing the respondent number 1 to 4.
2, 3 and 4.
2, 3 and 4.
2, 3 and 4.
2, 3 and 4. Miss, your name please? S.
Yes, Barik.
S. Barik, Learned Counsel is present on the respondent number 1. None is appeared for respondent number 5, although the name of the Learned Counsel is shown in the cause list. This matter has been heard in part. However, on the request of Mr. Nath, registry is directed to list this case again on 29th of Monday will post it. 29th of May. You are available on Monday?
Yes.
29th of May 2023 at 2 p.m. as a fixed part-heard matter. Whatever you want to do, you do, but I'm going to deliver the judgment.
If your lordship, just for the clarification, because with regard to my settled position of law, I have got the judgments. Should I hand over the judgments or?
Let us see what they have to say.
Yes.
You have not yet concluded. You have not yet concluded. So depending on what they have to say, you conclude your argument, we'll hear them and then we'll deliver the judgment. But the matter is very clear.
Yes.
You are aggrieved because of the seniority given.
Yes.
Nothing else.
Final part.
Both of them are in service.
Yes.
They are in service.
Yes, both of
Both of
them.
them
I
are-
think the other person
the
will
other
be
person-
retiring in June
June 20.
and this person will be retiring in September or October.
Any promotional prospect?
Yes,
Beyond
because he is, otherwise I'm into the next one, next promotion. That is resident,
Possibly for the
deputy resident commissioner.
deputy RPC, possibly petitioner has no, but otherwise the
If I'm-
service required is not there. 21.
No, that is a different thing. We are not on who gets what. We are on the question that once the High Court has set aside a particular action without preferring any appeal, without getting the order of the High Court incurred, again, administrative order is passed, restoring the same position back. That means that High Court order is nothing. That is what is, we are finding it
In
very
fact, this
difficult.
honorable court, while moving this matter as a motion item, has indicated that it has gone against this honorable court side.
That these aspects we will deal with.
I'll-
We'll deal with. And we'll deal it very hard because can't let these matters go on like this. The judges hear cases, the lawyers argue, people wait for years together. Once a judgment is given, if it is set at naught in this manner, then it will be a dangerous thing. We cannot take these things lightly.
Much obliged.
Yes.
Yes, my lord. They have filed the affidavit, my lord. In this affidavit, my lord, what I have submitted before your lordship, no merit list or select list, that is admitted, my
What
lord.
is the response to para 5?
In paragraph, paragraph 6 of the affidavit, my lord.
Yes.
That with regard to a statement made in paragraph 5 of the writ petition, the deponent begs to state that the state level recruitment commission for class 4 post has declared the result through the web portal, namely official website government of Assam and Seva portal, through which the candidates who had appeared for the interview can access their respective results in a secure and convenient manner. Accordingly, as and when assessed by the candidate, the final outcome status of their interview is displayed in the report. Nothing has been mentioned about the merit list or the select list, my lord.
No, but there, what kind of merit list? What is the scheme of?
Result, my lord, overall result, my lord. How many person has been selected for the?
You mean to say
respective-
there should be a merit list of all 13,000 candidates?
Yes, my lord, that should be prepared, my lord.
No, but why? Because you say so.
Because, my lord, there is the question of the reservation is come here, my lord.
No,
How
no,
many person is-
that when these issues crop up, then we'll see. But you can't just say that I want it this way, so issue a mandamus asking them to do it. That can't be the judgment you have relied upon is a completely different fact situation. Here, they were making appointments without preparing a merit list. Without preparing a merit list and without calling for options. That is why.
They are
this-
also saying, my lord, without preparing a merit list, they are going to appointment, my lord, on 25th, my lord.
No, the High Court proceeded on the premise that no merit list was prepared and the candidates who had aptitude for certain jobs or entitlement are required to be considered for appointment. Options had not been called for. No options was called for. So what do you say, Mr. Chaudhary, about this judgment? Bihar versus Kushal Kishore Singh.
Lordship, before that, Lordship may kindly peruse the scheme of examination for class 4 as per the rules. Frame under the Lordship Assam Direct Recruitment Commission for analogous post in class 3 and 4.
Where is the rules here? Okay.
Lordship, Rule 11 and 15. Lordship.
Mr. Borua, have you seen these rules?
No.
So these recruitments have been done as per these rules.
Yes, Lordship, because against the two qualification, Lordship, class 8 and HLLC, minimum there are 3 grade pays. And accordingly, the candidates who have secured the highest mark, taking into account their written examination and interview, they are placed in the higher grade pay. And according on exertion of that grade pay category, and the next person comes into the second grade pay. Only for the purpose of the grade pay, Lordship, the merit, whoever gets the highest marks, Lordship, accordingly they are placed. Otherwise, there is no such merit position, Lordship.
Otherwise, it is just pass fail.
Pass fail, Lordship.
Mr. Borua, you need to go through the rules.
Just a moment.
Not that simple.
Because under the ROP Lordship, against that class 4 post, there are 3 grade pays. Accordingly, as per their education qualification, Lordship, those has been classified.
Your Bihar judgment is not going to be of any use to you.
Yes, my lord. I don't know what is there. my lord.
All right, so that saves the day for you. If you had not given these rules, order would have been dictated. But anyways, can you give him a copy of the rules? Is it available? It is there. It's a gazette notified rule.
Gazette notified, Lordship. It is
Assam direct recruitment for class 3 and class 4 analogous post rules 2022. All right. When do you want it?
My lord, on 25th, my appointment will be made.
That can't be helped.
And leave it up to you. When it is convenient.
On
for you.
25th, it will be infructious.
After the infection.
Lordship,
Then you
take
all
it
go
up to-
today and we'll pass an order. What else can be done?
Then on 25th, my lord, in the first half. On 25th,
25th is Thursday.
Thursday.
Lordship may take it up tomorrow if he wants to, Lordship.
Tomorrow. On the prayer of Mr. D. Borua, learned counsel for the petitioner. This matter be listed again tomorrow for motion, so as to enable the learned counsel to examine the provisions of Assam direct recruitment for class 3 and class 4 analogous posts rules, 2022, and address arguments. Mr. D. Chaudhary, learned standing counsel
Lordship, state level commission, recruitment commission for grade 4.
for state level recruitment
3
commission.
and 4, Lordship.
That is respond numbers 3 and 4 is present before this court. You can take this back then.
Yes.
Bring it tomorrow. List the matter accordingly. You have to send a message.
Obliged.
Lordship, respondent number 2 and 3 only.
Which respond numbers 2 and 3.
May it please your lordship. And the matter pertains to my lord promotion of stenographer from grade 2 to grade 1, my lord. My lord, the rules holding the field envisage that an incumbent in a stenographer grade 2 service must have continuous 6 years of service and graduation from a recognized university. Now, my lord, what happened in the Secretariat of Department, my lord? My lord, the petitioner being a eligible candidate for promotion to the stenographer grade 1 is sought to be deprived by promoting undergraduates, my lord. That is the whole case. We have approached this honorable court and honorable court on the verifies they have passed the restraint order. Now may I just place the relevant rules, my lord.
You are for the petitioners in all the writ petitions?
No, I am for the petitioner in item number 12. And the other item number 13 is the, my lord, writ petition filed by the undergraduates, my lord. That has been tagged together.
You are in item 12.
I am representing petitioner in item 12.
And who is in item 14?
Item 14, lordship, we have the petitioner. Three petitioners.
All right. So there is a common grievance is common. And can you please repeat again, what is the basic issue here?
Yes, my lord, the matter pertains to promotion from stenographer grade 2 to stenographer grade 1. The recruitment rules provides that an
In
income
which department?
in this secretariat, my lord. Secretariat department. My lord, the recruitment rules provide that an incumbent in holding the post of stenographer grade 2 must have a continuous service of 6 years along with a graduation degree from a recognized university. Now the petitioner possesses the same, my lord. However, he is sought to be deprived of promotion by recommending undergraduate stenographers for promotion in his place.
So there are private respondents here.
Yes, they are private respondents.
Who is appearing for the private respondents?
They filed their affidavit.
They are not present today.
Names are reflected, my lord.
They are not present today.
What is the name of the private respondents council?
A call which one of us?
Not M.
Mr. M.
M.
Kolita
Kolita.
for respondent number 6 to 13 and item 12, my lord. It's indicated in the call list.
And my lord, A. Khoniker, I think he's the petitioner in 13. A. Khoniker and P. Kumar. They also will be required.
So in item 13, even the petitioners council is not present.
No. They are the undergraduates.
We included ourselves, your lordship. We included ourselves, respondent number 4, 5, and 6. Item number 13. Initially, when item number 13 was filed by the undergraduate stenographer grade 2, paying for combination of the education qualification. We are for the private respondents in number 13.
Actually, you see, since these are matters which are normally very keenly contested, can you find out if the councils are there?
Yes.
And give them a call, ask them to come. I wouldn't like to conclude the matter without.
Everybody has to be heard.
Because otherwise, what invariably happens is a review petition comes. And then we have to again redo the whole thing. So your client is a graduate.
Yes.
He has 6 years of experience.
Yes.
And therefore is eligible for being considered for promotion to the post of grade 1 stenographer in the secretariat. This is a part of the secretariat administration service.
Correct.
Comes
Now-
up the
Sorry?
Assam stenographer service rules 95.
All right. Now, what you are trying to do is you are trying to promote persons without graduation But they are senior to the graduates?
My lord, yes, my lord, and we have basically invoked rule 25 of the Assam stenographer rules, service rules 95. Where, my lord, it's specifically given, my lord, that where the government is satisfied that the operation of any of these rules cause under hardship in any particular case may dispense with or relax the requirement of that rule to such extent and subject to such conditions as it may consider necessary for dealing with the case in a just and equitable manner. My lord, here in this case, it is for administrative convenience we have done this. These people have worked also, my lord, so taking into consideration.
That's
because-
right, but are they senior to the graduates or junior to the graduates?
My lord, I think senior, I have some
You
cases,
think?
we have to see the different.
Well, there is a common list of, my lord. But my lord, what they are doing is, my lord, they are relaxing the conditions of recruitment, which is not permissible. Conditions of recruitment cannot be relaxed. The Honorable Supreme Court has time and again held, what can be relaxed is condition of service can be relaxed. And my lord, but the rules were amended, and as per amendment rules, 60% of the stenographer grade 2 will be filled up by way of direct recruitment. 40% will be filled up by way of promotion. So 40% at present, the promotional cadre strength is, my lord, 26. So out of 26, they have already promoted 16, my lord, by following the rules. Now, in respect of the next 14, my lord, they are now trying to do hanky-panky. And in the same secretary department, I also, my lord, the respondent authorities are scrupulously following the requirement of graduation. In respect of all other wings, my lord, regarding stenographers. Only in respect of this case, my lord, they are trying to deviate. There are assistants who are sought to be promoted for superintendent. My learned friend is appearing. Their stand is, my lord, no, graduation is a must.
These matters are also pending.
Yes.
Then why don't we have it together? Then it will be
Yes.
interesting to see what is the standard.
In my affidavit in reply, I have said so, my lord. I pointed out.
Which case?
Assistant to the superintendent of local secretary.
Do you have the case numbers?
Right now, I don't have. But I have the notification, my lord. I have the notification.
No, if we take these matters together, then the government will have to take one stand.
And he is
Mr.
aware, my
Fukan
lord, he has appeared before a division bench also. It's not.
Mr. Fukan will be in deep trouble.
My lord, last occasion, my lord. I'll have to look well which case he's talking about.
Only deviation only in this particular case, nothing else.
Yes, Mr. Sharma, could you?
There's the entire corridor is desolation, or there are just few.
Lordship, my senior is on legs, Mr. UK Nair in court 7, Lordship.
Now, I can continue with the matter, but then the petitioners are not there. There again, respondents in some of it. Your matter is heard. I just need to hear the other side now. I can deliver the judgment almost. But what to do?
My lord, lordship has to hear everybody before taking a call. That is obvious, my lord. But my lord, everybody has been promoted and my retirement is also due in next 2 years, my lord.
2 years.
Well, 2 years goes. 1 year has gone by already, my lord. I filed a petition.
All right, you have urgency. There's no doubt about it. Well, give them one chance.
Yes, ma'am.
We're recording that.
And I expect, my lord, the state respondent comes with clean hands, my lord, because in the same department, they are taking the stand, no, graduation is a must. Only in case.
So can you give the number of the other cases later on? If not,
I'll try, my lord, but I have the notification. That notification I can,
what is the notification?
my lord, right now I have the soft copy, my lord.
Give the soft.
My lord, office order dated 28th of March 2023, bearing number ECF number 223049/58. Issued by General Administrative Department, Secretariat Establishment. Here, my lord, promotion was made for senior grade computer operators. And my lord, they have scrupulously followed that graduation is a must. And recently, my lord, irrigation department also from grade 2 stenographer to grade 1 stenographer promotions were made. Who were undergraduates, even they were senior, they were not promoted. Only the graduates were having.
But if you take differential stand, depending on the case on the same issue, this is bound to create heartburning and create generate a dossier for urging that there is violation of Article 14 and 16. In some cases, you prefer graduates over undergraduates. In some cases, undergraduates over graduates.
Generally, my lord, the rule says, my lord, it's graduate only, my lord, but in this case, they had invoked the principle of Rule 25.
And
That is what not in all cases we have invoked. We follow the usual process, my lord. That is what the
this
council has said, my lord.
requirement of graduation for promotion to grade 1.
Grade 1, my lord, it's mandatory.
This was always the requirement of the
Yes.
rule,
No,
or-
my lord, that
Yes, from 1995.
1995, that's what.
and these undergraduates were recruited after 1995.
My lord,
The undergraduate grade 2 stenographers,
my lord.
who are the petitioners in item 12, where they recruited, not item 12, petitioners in item 13, where they recruited after the rules of 1995 were framed or before that?
Check up.
My lord, the petitioner in item number 13 was
After
appointed.
that, after the rules have come into place, Your Lordship,
After,
all the individuals who were arrayed as parties in this writ petition, Your Lordship, they had come into service after the advent of the 1995 rules.
Then as per the 95 rules,
The graduation was a requirement. The only change that has happened was the proportion of direct recruitment to a promotion, which is 60 to 40%, which was brought about by the amendment of 2020. But the crux of the requirement needed to be grade 2 and grade 1. It was always graduation. But they had come into service knowing full well the rules of the project.
then it will be different.
And my lord, who has initiated? DPC was conducted for our promotion, for my promotion. Now the DPC says that nothing will. You go and relax the rules. How can it, what business DPC has to, my lord? To direct for relaxation of rules, my lord. Then I have relaxed, my lord. And my lord, they will have to satisfy your lordship that I will submit to judgment, my lord, that conditions of recruitment cannot be relaxed. If they have a grievance, they can
Not
always say
conditions of recruitment, rules of recruitment.
rules of recruitment.
Where is the judgment? Let us see.
My lord, lordship will kindly see the first order it's quoted, 1/6/2022. While granting interim order. Order dated 1/6/2022, my lord.
it's a land of the
No, in this order, the judgment that is quoted, which says executive instruction cannot supersede rules framed under.
Yes, that is another legal point, my lord. The executive fiat cannot supersede rules framed under Article 309. They're also there. My lord, here.
No, but Mr. Patwari, there is another aspect which you will have to meet.
My lord.
You see, rules of recruitment cannot be relaxed.
True, my lord.
But that will apply when it is a question of initial recruitment.
True, my lord.
This grade 2 to grade 1 is a promotion.
Promotion.
It is not a direct recruitment.
Yes.
It is a
60%
promotion.
direct, 40% promotion. We are
Correct.
concerned with the 40%.
You are concerned with the promotion. Therefore, the question of rules of recruitment does not come here.
My lord.
When you are promoting,
My lord.
promotion is done on the basis of two things. One is the person must come within the zone of consideration.
True, my lord.
That means eligibility.
True, my lord.
And the other is the criteria of promotion.
Here merit comes.
Right. Now, if the employer feels that operation of a particular rule, that is requirement of graduation, is causing undue hindrance or is operating in a harsh manner for X, Y, Z candidate, then can it be said that the employer would not have the power to relax the rules?
Definitely, but it has to be uniformly done, my lord. It cannot be done on a pick and choose basis, my lord.
No, uniformly done means other matter, so you are not appearing. Are you appearing in this case?
No, I don't think we are not.
So we'll have to go by the facts of these three writ petitions. You are saying that you cannot relax because it is not relaxable.
Yes.
That is your argument.
Yes.
But if the court finds or if it turns out that they have the power to relax this, then what is your alternative argument?
No, my lord, then also, my lord, by an executive fiat, my lord, the second point will come in, my lord. How can they overreach the rules by an executive fiat?
No, it's not over. There is a power to relax the rule.
Yes, my lord.
Is it not there?
Rule 25, my lord, of the Assam Stenographer Service Rules 95.
That, what is the rule? Please read it.
The rule, my lord, is where the government is satisfied that the operation
25.
satisfied. My lord, I'll read it, my lord. Where the government relaxation, where the government is satisfied that the operation of any of these rules cause under hardship in any particular case may dispense with or relax the requirement of that rule to such extent and subject to such conditions as it may consider necessary for dealing with the case in a just and equitable manner, provided that the case of any person shall not be dealt with in any manner less favorable to him than provided in these rules.
So this relaxation clause is same everywhere in all rules. It is the same. Now, Mr. Patwari, the point you have to meet is,
My lord,
if the power is there under the rule and the government exercise that power, the only ground of challenge would be to say that the power has not been exercised in a manner acceptable under
in
the
a valid manner.
What is your argument on that?
My lord, having a power is a different thing, my lord, and exercise of power in a valid manner is a different thing. If you
Are you prepared to answer that question, or you need to do some research?
I'll have to, my lord, go through that.
So you do some research and come. These things are very firmly entrenched areas of law. There are decisions, pre-decided cases.
True,
which
my
have been-
Because having a power is a different thing and valid exercise of power is another thing.
Correct. So if the power is there, unless you can show that it was exercised arbitrarily, the read court will not interfere.
True.
Is it not? So that is where you'll have to argue. If the
Let
power
the
is there, they can exercise. And it is not pick and choose. Pick and choose will be if one set of undergraduates are favored, then the other set is not favored in the same class.
No, here the other
No,
way.
that is another category. That is superintendent. You are not concerned with that.
No. My lord,
And my lord, that is different. That which case I think he's talking about. That is the advertisement was floated by the, I think, the district establishment, where NTC certificate was a mandatory thing according to the stenographer rules. There, my lord, without giving the that like NTC, the National Technical Certificate you have to possess, they floated a advertisement long back. That case I think is pending. I think he's talking about that.
So Mr.
That doesn't
Patwari,
match
examine
with
this
this
case.
case.
I will examine, my lord. Lordship will kindly come to page 59 for one. Just one.
Page
59 of the writ petition. Item 12. As I have already indicated, my lord, the promotional quota of 46 comes to, my lord, cadre strength of 26 stenographers. Now, this was issued on 30th of March 2021. Subject to discharge without notice and without assigning any reason thereof, the following stenographer grade 2 English in Assam as secretary are promoted temporarily until further order for a period of 1 year and appointed to officiate as stenographer grade 1 English in the. So, my lord, these 16 out of those 26 have been already promoted to grade 1, my lord. And my lord, below down, this order shall be subject to outcome of writ petition 516, that is item number 13, my lord. However, in our case, Lordship will kindly come to the next page, page 60. This is the minutes of the impugned DPC, my lord. Page 62, my lord.
So why these promotions are made under 4D? Vacancies are not available. Mr. Fukan,
But that I have to get my answer.
you have a notification of 2015, 16th of March 2015, where the government in the personnel department, additional chief secretary personnel, has issued the notification deprecating this practice of 3F and 4D. Then why have you done it here? What is the reason? Are you aware of that?
My lord, I'm not aware. The personnel department will be.
You are not aware of your own
My lord,
notification.
No, not my notification. That's the personnel department.
Oh, the government only.
I'm departmental counsel, my lord.
Which department?
SAD, my lord.
SAD.
GAD, I mean, my lord.
It's a cousin, it's
I
a
know.
colonial cousin of personnel. What else is that?
Well, I'll get hold of it, my lord. But
Just to complete my for today, my lord. I have shown that out of 26, my lord, 16 have been promoted. Lordship will now kindly come to 63, page 63. The rest 14 were also considered, and this is the observation of the DPC, the last para. After examination of the court order and considering the other aspects, the selection board advised the department to move for one-time relaxation of educational qualification in respect of the undergraduate incumbents in both the cadres of stenographer grade 2 and grade 3 to make them eligible for promotion to the next higher cadre. Until then, selection board decided to defer the recommendation of candidates to fill up the vacancy of stenographer grade 1 and stenographer grade 2 by a promotion. My lord, how can a departmental promotion commission take interest whether rules are relaxed or not, my lord?
Yes.
For 16, they have given the promotion, and for rest 14, now this is their observation. Had it been the government who had invoked that relaxation clause, I could have understood. This is a DPC matter.
No, then after this, has the government done anything?
No, thereafter, my lord, a cabinet decision was, my lord, then we approached the honorable court and the restraint order is operating.
What is the stand of the government?
They have filed their affidavit, my lord.
I have filed the affidavit, my lord. They, my lord, have stated, my lord, this thing that, my lord, we have invoked the rule 25, my lord. In this case only, my lord. My lord, we have used invoked the principle of rule 25 of the Assam stenography rules as a measure of one-time relaxation.
Mr. Patwari,
My lord,
you will have to
I'll
do some
satisfy-
work here. Huh?
I'll satisfy your lord.
It is not as simple as. it
I'll
looks
satisfy-
like. So anyways, you take down, heard Mr. Mr. Nair, you are appearing in this case.
No, I'm not, because for last 3-4 days, no, they have not been contacting me, no, nothing. I've been asking for instructions, that also did not come to. 2 consuls, my lord, I don't know. They had engaged me, but thereafter, my lord, they have never. If not possible, my lord, I'll contact them again next day.
Really, all right, you don't get into all that.
I'm not just keeping myself away.
You keep yourself busy with bigger things, not this.
This is more big, interesting. And that 4D thing, that's a misnomer going around, madam. 4D, that promotions, all promotions till today are made under 4D. It's a misnomer, madam. The provision of 4D comes under 320, that exclusion, which matters need not go to APSC, madam. The APSC's clearance is not required. It is under that, madam, this limitation of function regulation is made. But still, although there being a rule, they are still, madam, all the departments first 4D, then the file goes to APSC, comes back, then regularized.
The 4D probably gives them something, is the.
It's a
3F
regular promotion otherwise.
It is the 3F equivalent of
No,
promotion.
No,
Then?
no, madam. 3F is an ad hoc appointment.
Hmm.
4D is an appointment, my lord, in 99% cases made after the matter is routed through the selection committee. It's not a pick and choose method, my lord. Still they are given under 4D because the APSC approval does not come. It's a gazetted post, so
That's
they said
right. So pending approval of,
APSC.
no, but 3F can be done without holding any selection.
Lordship.
process. Correct.
Lordship.
But subsequently, APSC can hold a selection and regularize them.
Regularize them.
That's correct.
That's true.
And in 4D also, there can be promotions without approval of the APSC.
APSC.
But subsequently, APSC can call them for interview and regularize them.
Only the file goes, and in the file an approval is given.
Whatever.
Selection is done by the department. So that 4D thing, my lord, is a little bit misnomer, according to me. It should be regular promotions. Then that will come. If required, my lord, they'll pass a regularization order or something like that. But that, not doing that, they give it on 4D.
Heard Mr. J. Patwari, learned counsel appearing for the writ petitioner. Writ petitioner in item 12. Also heard Mr. M. Sharma, learned counsel for the writ petitioner in item 14. Good stuff. Mr. A. Fukan, learned standing counsel SAD is present on behalf of the department. However, the counsel for the petitioner in item 13, who also represent the private respondents in the other two writ petitions, are absent today, although the name of the counsel have been duly reflected in the cause list.
Yes.
Considering the nature of controversy involved in these writ petitions and the relief that has been prayed for, this court is of the opinion that for the ends of justice, one more opportunity should be given to the aforesaid counsel who are absent today, to appear and argue the matter. Stop facilitating the above. These writ petitions are directed to be posted again on
As per in lordship confidence, because I will be praying for a final disposal.
1st of June 2023 as fixed items.
Deep level.
You come prepared on this.
Yes,
First-
I've got it.
First, you have to show what are the parameters for exercise of powers of relaxation. What norms are to be followed. Then what is the scope of judicial review of exercise of such power? But then the government has not exercised the power.
It is the DPC.
It is only the recommendation of the DPC. So he's right. How can the DPC, that is not the mandate of the DPC. DPC is to consider the candidature of the persons coming in the zone and make the recommendation. So the entire procedure of the DPC will stand vitiated now. That means the DPC had some other agenda.
Vested interest.
Does it not mean, Mr. Pupan? DPC has an agenda. The whole purpose of DPC is to insulate the process from any agenda. But here,
And I won't comment.
all right,
Deep level.
you don't comment, but you let us know. Yes.
May I pleases your lordship? My senior P Nayak, he is on the legs, your lordship. Although
They will always be on legs. What to do?
matter is going on, your lordship, although he is very much here.
When the court is in the
earlier.
seat, that is what should matter more. Council on leg, court is on seat, what to do? You better go through the brief and argue. Otherwise, we will be without work.
Your lordship,
We
time
will
being-
go without work, unemployed for the day. Because out of 15 cases, 14 cases, somebody or other is on the legs. That means we'll have to stop working from 12 o'clock in the morning.
I pray for time being, your lordship. Can you pass over the matter
All
for
right,
time?
5 minutes. Yes. Mr. Nair can start. What is the matter, Mr.
My
Nair?
lord, the matter pertains to promotion from the rank of, my lord, assistant executive engineer to executive engineer. My lord, this person was qualified, but in 2015, an FIR was lodged against him. This FIR, my lord, led to a charge sheet being filed on 31/7/2017. That charge sheet number is 14 of 2017. Now, my lord, this charge sheet upon was then summons were issued. Thereafter, my lord, the court examined the charge sheet, found that it's not proper. It remanded back the matter, my lord, the words used is reinvestigation. The matter went back. Thereafter, my lord, nothing was happening. Suddenly, my lord, they woke up. Again, a reinvestigation was done and a fresh charge sheet was filed. in 2022. And my lord, there is an affidavit in an earlier case wherein they have categorically stated that we reinvestigated the matter in terms whether reinvestigation is permissible or not. My lord, that's a different issue altogether. My issue here is, my lord, on 2021, my lord, when my lord, the promotions of persons junior to me were considered, my case was considered, my case was kept in seal cover, my juniors were promoted because they were under impression that in 17 the charge sheet was there. But once it went for, my lord, reinvestigation, the charge sheet was not there. Charge sheet came in 22 only. Now, interestingly, my lord, they promoted my juniors, and my lord would see how they have dealt with my case. My lord comes to page 36.
Mr. Nair, can you just sit for a couple of minutes?
Lordship.
Yes. So they did consider your client for promotion, but kept it in seal
Seal
cover.
cover?
But at that time, there was neither any charge sheet
No, not charge sheet.
submitted.
Lordship.
But today also has charge been framed?
No, there is a stay order operating because, my lord, under the PC Act, they had added the PC Act by the Chief Judicial Magistrate. On that count, the criminal appeal was filed. And my lord, that is the whole proceeding is under stay. Without sanction, there was no sanction also. But my case is, my lord, once for any reason, it may be right, it may be wrong, that charge sheet having been returned for a reinvestigation, there is no charge sheet in the eye of law. My charge sheet came in 22. The promotions to
Investigation or further investigation?
it should have been, my lord, further investigation. But here in this case, it is reinvestigation.
Where is it?
My lord would come to page 49. Mm. 8/8/2019. Accused are absent with steps, white petition so and so. Heard both sides and the petition is allowed. I have gone through the record and seen that there is some mistakes in the charge sheet. And as such, it appears to me that further investigation on certain point is necessary. Hence, let the case records be sent to so and so to reinvestigate the matter and submit FF at the earliest, inform accordingly.
What is FF?
Final form. And accordingly, my lord, next page, they submit the final form, FF, my lord, charge sheet, without any reference to the earlier one. This is of charge sheet number 12 of 2022. Earlier one was, my lord, 14 of 2017, 14 of 2017. The number is different, no linking back, my lord. And lordship would remember, see one thing, I find it very, at page 37, there is a gradation list of executive engineers. It starts at page 36. They are just waiting for me to come back, my lord, to the cadre. They have already assigned a place for me at serial number 70. My lord.
Page 37.
37, serial number 70. I have already been assigned a place, my lord. But on the seal cover.
Yes.
He seems to be on like
Who is
Mr.
reporting?
Nayak, my lord, Padma Nayak. Padma Nayak is for the education, the PWD.
Your
Is on
Lordship, P.
field.
Nair, his
Yeah.
submission is going on, your lordship,
No,
in
what
court
to
number
do?
2, your lordship.
What
So
to do?
some-
We are also going on.
Tomorrow, your lordship,
No, we can't adjourn these matters like this. You argue, you are there for the
your
department.
lordship, I'm very much new to that chamber, your lordship.
Who said you are not new?
Your lordship, I'm attested to that chamber very newly, your lordship,
Then
and
what to do? We can't
I'm
keep
not-
postponing matters like
I'm
this.
not allotted for PWD, your lordship.
What is your allotment?
SSA, Ramsa, then your lordship BTC. So,
Then
your
you
lordship,
must give us a list of who's got what allotment.
Tomorrow, your lordship.
Mr. Nair, what to do?
But I don't want her to be in trouble. My lord has already got the point.
Heard submissions made by Mr. UK Nair, learned senior counsel appearing for the relief petitioner. Full stop. However, a prayer for adjournment has been made on behalf of the respondent numbers.
It would be respondent numbers, my lord. 1,
One.
2, 4.
1, 2, and 4. That is Mr. P. Nayak.
And also your lordship, BTC, your lordship, that
1,
is
2,
the
3.
respondent number 3.
1, 2, 3.
He is appearing, your lordship.
Then learned counsel for the respondents.
Yes, your lordship.
That is Mr. P. Nayak, on the ground that he is in the middle of argument in another case, full stop. In view of the above, this matter is directed to be listed again as a fixed item day after tomorrow.
Lordship.
Yes, sir. Deeply obliged. For hearing item 20.
Tell him.
Item 20.
Yes, what is the matter?
Matter relates to your lordship disciplinary proceeding, your lordship. The petitioner was inflicted a punishment of compulsory retirement, your lordship. That he has put to challenge, your lordship, way back, it is 2011-13, your lordship. In the meantime, has attained the age of superannuation also, your lordship, by this time. Now, your lordship, the issue, the charge sheet, your lordship, was in fact, first, your lordship, an explanation was called, your lordship, which is at page 22, which will give an impression about the nature of charges, your lordship, brought against him, your lordship. And basically, your lordship, allegation against the petitioner, your lordship, that he has made certain accommodations towards, your lordship, for customers, your lordship. And by without
Where is
having.
the order of penalty, please?
Loss. That is, your lordship will get it at page 122 euros. Married euros. This is reference to the departmental inquiry held by Sri K.K. Dasgupta External Inquiry Authority into charges levied.
He was working in the Union Bank.
Union.
As what?
As you in the managerial category, so branch manager at the relevant point of time, task for branch units. Inquiring authority has since submitted his findings and the same were forwarded to Sri Purkast also and on 8/12/2010. He received the same on 8/12/2010. Sri Purkast has made his submission on the findings of the inquiring authority on 14/12/2010. The undersigned has gone through the opposite article of charges issued to Sri Purkast. Inquiry proceeding exhibits produced during the course of the inquiry, findings recorded by the inquiring authority, submissions made thereon by Sri Purkast and other connected papers in the matter. The materials evidence adduced during inquiry established that Sri Purkast has passed series of fake entries amounting to rupees so and so, debiting 10.6 lakhs, debiting suspects account, clearing checks on hand without checks from time to time, allowed wrongful accommodation to 4 customers of the branch. He has abused suspense account, clearing checks on hand by putting through these spurious transactions. Further, Mr. Purkast debited expenditure account, electricity, lighting charge, so and so on 9/1/2009 and credited the amount to sundry others miscellaneous. He debited sundry other miscellaneous with rupees 50,250 on the same day, that is on 9/1/2009, and credited pay order issued this account issued to pay order rupees 50,250 dated 9/1/2009 favoring HDFC SLIC. Sri Purkast on behalf of the project director DRDA paid this insurance premium. He admitted having made such payment. His contention is that he did so to satisfy project director DRDA for mobilizing deposit to achieve business target is not acceptable. The fact of offering illegal gratification by him and indulging in such unethical practice for consideration is not justified at all. Sri Purkast had debited expenditure account, meeting expenses on so and so that he did not seek rectification from competent authorities. There is no record as regards the names of the customers attending the meetings, the occasion, deliberation, minutes of the meeting, and the communication to regional office informing about such meeting of the copies of minutes. It is brought out in the inquiry that undue accommodation amounting to rupees 106 lakhs extended to our customers and the branch has been fully recovered with interest. The interest amount was recovered from the parties on 28/2/2009. Sri Purkast has also deposited so and so being total amount of wrongful spurious debits to expenditure has filed his letter dated so and so and requested the bank to appropriate the amount towards financial irregularities committed. The manner in which Sri Purkast had allowed accommodation was unethical. The entries are fake, therefore cannot be justified in view of foregoing. It is evident that Sri Purkast abused the delegated authority vested on him while discharging his official duties. He failed to monitor the affairs of the branch, which facilitated in fraudulent transaction and withdrawal of money without proper authentication. It is also established that Sri Purkast had no control over the routine matters and failed to supervise day-to-day functioning of the branch and had not exercised due care and diligence to safeguard the interest of the bank. Based on the allegations proved during the inquiring authority has held following charges to be proved taking Purkast and understand concurs with them. Failure to take all possible steps to ensure protect the interest of the bank, failure to discharge his duty with utmost devotion and diligence, failure to discharge his duties with utmost honesty and integrity, acting otherwise than his best judgment in the performance of official duties. Taking into consideration the nature and gravity of the aforesaid charges, allegation proved against Purkast, the undersigned is of the opinion that ends of justice will be made by imposing him a major penalty of compulsory retirement from the service of bank with immediate effect. Accordingly, I hereby pass the following order in exercise of power vested in me in terms of Regulation 7 of Union Bank of India Officers Discipline and Appeal Regulation 1976.
So he is getting pension.
Till date, she has not received pension. So there is an order from this honorable court directing them to release my pension during earlier deliberation, Your Lordship. That order they have not complied.
So now he has attained, as you say, he has attained the age of superannuation. So effectively, assuming he may not, but assuming he succeeds, what is the relief? he'll
Relief,
get?
Your Lordship, he will get only the notional benefit so far as Your Lordship, for fixed salary so far as the fixation of pension is concerned. More than that, Your Lordship, it is ultimately Your Lordship. That's why probably Your Lordship in an earlier hearing, Your Lordship, the coordinate branch of this honorable court, Your Lordship, directed them to take to see if some other punishment can be given to him. That was the direction, and they were supposed to place that direction, Your Lordship. Order to be placed.
What is the date of the order?
The order is Your lordship may kindly peruse 6/1/2023. My case, your lordship, essentially was that this is disproportionate because your lordship, what I did for the interest of the bank. So far as this giving gift to the officers and others are concerned, your lordship, that this is the practice, routine practice in the banking industry nowadays with the heavy competition for the deposits, your lordship, more particularly from the private banks, your lordship, there is a pressure from the high ups. And therefore, these practices and evidence they have, your lordship, brought into record, your lordship. That will also, your lordship, in cross examination, their witnesses have admitted that yes, such things happen sometimes. And I say my submission was that, your lordship, that because to ensure deposits in the bank, I provided those gifts, and it is not for my benefit. And
So what is the allegation against you that you have provided some gift?
Gifts, etc. by your lordship will note that, your lordship, since I am not paying from my pocket, your lordship, that through this customer meets, etc., I have to, your lordship, get that money, your lordship, to give gift to the authorities, your lordship. One DC, one HDFC life insurance for one project director. These are the things. And so far as the other main allegation is concerned, your lordship, that giving undue advantage accommodation to certain clients, your lordship, my justification was that they are very valued customers. They have been their deposits are there for long period of time, and to accommodate them on the basis of the bills, government bills, I have accommodated them for certain period of time, and then entire money
Where
has
is the
been.
memorandum of charge?
That is, your lordship will get. Annexure C, your lordship.
Annexure C.
See page 28. Article of charge. This is reference to
Mr.
the.
Sharma, why don't you take your seat?
Yes, your lord.
You argue when your time comes.
Yes,
Or you are very eager to argue.
no, your lordship, I always have an habit.
This is reference to the explanation dated 14/5/2009 submitted by Sri Manish Purkasto in reply to so-called memorandum number so and so issued to him by Regional Office Guwahati. The explanation submitted by Sri Purkasto has not been found convincing or satisfactory. It is reported that Sri Purkasto, during his tenure as branch manager, Tezpur branch is resorted to unauthorized debit from various expenditure and impersonal accounts which are credited to different accounts and subsequently withdrawn. Misuse of expenditure account and lack of supervision and control over the routine matters of the branch was also observed on his part. It is reported that Sri Purkasto had fictitiously credited rupees 106 lakhs to various accounts such as Daishwal Trading Company, NK Enterprise, Ved Prakash Sharma, 1A Traders of the A1 Traders at the branch. It is also reported that he abused delegated authority vested upon him while discharging his official duties day-to-day function of the branch. The secrecy of the individual user ID and password was not maintained at the branch. He failed to monitor the affairs of the branch, which has facilitated fraudulent transaction and withdrawal money without proper authentication. He did not apprise the controlling officer about happening of the branch. It is therefore evident that Purkasto had no control over the routine matters and failed to supervise day-to-day functioning of the bank, and had not exercised due care and diligence to safeguard the interest of the bank. The aforesaid acts of commission and commission as brought out in the so-called memorandum dated 27/4/2009 issued to Sri Purkasto constitute the following misconduct on his part, and he is hereby charged the same: failure to take all possible steps to ensure protect the interest of the bank, failure to discharge his duty with utmost devotion and diligence, failure to discharge his duty with utmost honesty and integrity, acting otherwise than in his best judgment in the performance of the official duties. Sri Purkasto is informed that Sauka's memorandum number so and so dated 27/4/2009 issued to him will form the statement of allegation for the purpose of article of charge. The list of documents through which the list of witnesses through whom the above allegations are proposed to be substantiated is enclosed. This Purkasto is hereby advised to submit his written statement of defense within 7 days from receipt thereof by him as to why further disciplinary action should not be taken against him or the above lapses on his part. He has the permission of the undersigned to inspect relevant records, documents at the Tezpur branch for a duty day to enable him to submit his statement of defense. In case he fails to submit his statement of defense in a matter within stipulated period, it will be presumed that he does not wish to avail the opportunity given to him in the matter and will be proceeded further on this basis. Now, if your lordship comes to next prior page, your lordship, my reply to the first explanation, your lordship, page 25 onwards, your lordship. So far as this allegation of your lordship giving undue accommodation to the 4 customers are concerned, your lordship, I have what I have stated, your lordship. Paragraph 5 onwards, I have never acted against the interest of the bank and I have not discharged my duties with malafide at any point of time, and bank has not incurred any loss arising out of that. The accommodation made to 4 valued customers for a particular period of time based on following reasons. Mr. Joshua Trading Co. was an established and reputed wholesale food grain dealer and supplier against GoF orders against the bill submitted to GoF departments. Initially, he was accommodated rupees 20 lakhs on 21/1/2008, against which between 21/1/2008 and 28/1/2008, the said party deposited 50 lakhs to the branch. Similarly, against the accommodation of rupees 11 lakhs on 28/1/2008, the said party deposited 29 lakhs on 28/1/2009 to 31/1/2009. Messrs. NK Enterprise was a reputed GoF contractor with good means of accommodation with rupees 20 lakh against GoF bill on 11/3/2008, adjusted on 31/3/2008, and to whom bank sanctioned rupees 35 lakhs as advance on 31/3/2008. Messrs. Ved Prakash Sharma, another reputed valued GoF contractor, was accommodated with rupees 12 lakhs on 6/3/2008, which they had of course adjusted on 8/3/2008 against GoF payment order for rupees so and so, which was ultimately cleared and credited in the account on 4/4/2008. Messrs. A1 Traders, another valued and reputed customer of the branch and supplier of GoF orders, accommodated against GoF bills, deposited rupees 5.330 lakhs on 50/10/2008 on the day of accommodation itself and paid rupees 30 lakhs in the account within 30/10/2008. The said party had cash credit limit with us and never exceeded the limit and at any point of time. Moreover, an ad hoc proposal for rupees 25 lakhs for completion of GoF work was sent and pending at NRO Guwahati for approval. The above accommodation made was also properly charged as per norms of the bank and branch, earned substantial amount towards income as interest on TOD. The expenditure incurred by branch at the direction of NOR, and then there are, your lordship, some of the expenditures which have the
So now your only ground is that some other punishment.
Lordship, that is what your lordship.
And
Because your lordship, apparently your lordship, although your lordship inquiry officer held that what I did, it is unethical, your lordship. It is not said that with any malafide intent.
where is the finding of the inquiry?
Your lordship will get the inquiry report at your lordship page. Page 100. It starts from, let's say, 90.
So no loss caused to the bank as such.
No.
But some activities are
Page 78.
Yes, your lordship.
not strictly in terms of discipline.
Yes, your lordship, we are dealing with the public money and.
That's correct.
Yes,
Can you not consider some other penalty?
your lordship, that we cannot, because we do not have such power to consider it.
Then we'll ask you to do it.
Yes, your lordship, that is always be.
Yes, which page?
Page, your lordship, it starts from page 78, your lordship.
No, relevant part,
that-
unethical.
I will come. Your lordship, may kindly see page 88, your lordship.
Page 88.
Page 88, one of the findings, your lordship. It is true that the accommodations granted to 4 customers, namely so and so, so and so, so and so, and so and so, were recovered with interest from those beneficiaries. Nevertheless, The manner in which Sri Manish Purkayastha allowed such accommodation is unethical. This is one of the findings, Your Lordship. So far as that is concerned, and then if Your Lordship comes to page 95. In fact, Your Lordship, I have admitted all those things in my before the disciplinary inquiry officer, page 95, the CSO debited expenditure account number so and so charged with rupees 50,000 on 9/1/2009 and credited the amount to sundry others miscellaneous. He debited sundry others miscellaneous with rupees 50,250 on the same day. On so and so credited pay order issued account issued pay order for rupees 50,250 dated 9/1/2009 favoring HDFC SLIC. This insurance premium is paid to CSO on behalf of the project director DRDA. The CSO admitted having made such payment but contended that he did so to satisfy the project director DRDA for mobilizing deposit to achieve business target. No business should be solicited by the offering legal gratification. The CSO cannot indulge in such unethical practice for any consideration whatsoever.
You reconsider the charge, anything below compulsory retirement. And thereafter impose fresh penalty and then proceed to give him consequential benefits. Reduction of pay scale, etc. These are also there.
Yes, Your Lordship, just only one submission, that it is a matter of fake entries and unauthorized debits. If that be allowed, then it will be always an happening, because
No,
public
nobody is
sector
allowed.
bank
Nobody is
never says.
Nobody is giving clean sheet.
Yes, Your Lordship.
Your inquiry officer has also said that this amount has been recovered.
Yes,
He is
amount
not
has been
coming back to
recovered.
the bank.
Amount has been recovered, but it there after that, page number 88, which has been just referred, the last two
But
lines.
he has personally not taken any money. His point is that this was done for business development. This may be unethical. That's what the inquiry officer said. But he has not taken any money himself. And this has not resulted into any loss to the bank. These two things are coming out from the inquiry officer's report.
Your Lordship,
So-
just page number 88, Your Lordship, that is
Ah.
the fake entries he has made in the accounts. Because we are answerable to the RBI also.
Nobody is exonerating him.
Yes, sir.
Just the penalty, you review the penalty and impose any other penalty on him. Less than compulsory retirement. And in any case, he cannot come back to service. There will be no reinstatement.
There will be no.
Then reduction of pay scale, etc. will be the same effect.
Yes, Your Lordship may pass, but. I
All right, heard Mr. S. Botakur, learned counsel appearing for the writ petitioner, also heard Mr. M. Sharma, learned counsel representing the respondent bank. First up, the order of penalty dated 21/04/2011 imposed upon the petitioner of compulsory retirement from service of the bank with immediate effect has been challenged in the present petition entirely on the ground that the order of penalty is shockingly disproportionate viewed when viewed in the light of the findings recorded by the inquiry officer, full stop. The facts of the case, comma, in a nutshell, comma, is that the petitioner was an employee of the Union Bank of India, full stop, while serving as the branch manager of Tezpur. Branch manager of Tezpur branch.
branch.
Yes, sir. It's full fine.
Tezpur branch.
On 13/7/2005.
A departmental proceeding was initiated against the petitioner on the following charges, page 29 of cover, 1, 2, 3, 4. Full stop. Although the writ petitioner had denied the charges brought against him by contending that the alleged manipulations of accounts and payment of gratification made by him was for the purpose of business development. The departmental authorities did not accept his explanation. Full stop. Eventually, the enquiry officer submitted his report dated, what is the date of the report?
Lordship.
What is the date of the enquiry?
Lordship, I am. 25/11/2010, page 116.
25/11/2010.
10, page 116 below.
Held that the allegations brought against the writ petitioner were proved. Full stop. Based on the enquiry report dated 25/11/2010, the impugned order of penalty dated 21/4/2011 has been issued. Full stop. Since, no, full stop. Mr. Bhattakur submits that during the pendency of this writ petition, his client has retired from service.
On
No,
30.
his client has surpassed the age of retirement. And therefore, at this point of time, the only relief the petitioner is seeking in this case is for interference with the order of penalty. Full stop. Since the basic ground on which the petitioner is assailing the order of penalty is that the same is shockingly disproportionate to the gravity of misconduct as alleged and found to have been established by the enquiry officer, it would be necessary for this court to reproduce the findings and observations of the enquiry officer with regard to the allegations brought against the petitioner as reflected in the enquiry report. Full stop. With regard to the allegation number 1, the conclusion of the enquiry report officer is as follows. Page 88, double tick to double tick. Page 88. Insofar as allegation number 2 is concerned, the enquiry officer has found as follows. Page 95, double tick, double tick. Full stop. Where is allegation number 3?
3, your lordship, that is page 11111, your lordship.
Now, allegation number 2 to apne divo. Page 111, double tick to double tick. 111. Allegation number 2. Findings of allegation number 3, which page?
It starts from allegation number page 111.
Conclusion.
Conclusion in 114, your lordship.
Allegation number 3, here also, the inquiry officer has held that the allegation was proved. The observations made in the inquiry report on the above count are reproduced herein below for ready reference. Page 114 double tick to 115 double tick. Full stop. From a careful reading of the inquiry report, it is apparent that the petitioner was involved in making certain fake entries and extending certain gratifications to persons mentioned therein. But according to the petitioner, such activities were directly connected with the idea of business development, and the same did not result into any loss having been incurred by the bank, since all the amounts would subsequently be recovered. Full stop. Mr. Sharma, learned counsel for the respondents, has also not denied or disputed the fact that the bank did not directly suffer any loss due to the activities of the petitioner, but he has argued that the respondent bank, being a nationalized bank and being the custodian of public money, cannot tolerate such indiscipline from its employees. Full stop. Therefore, these are cases where stringent disciplinary norms are required to be enforced by the bank. Full stop. After hearing the arguments advanced by learned counsel for both the sides, this court is of the opinion that there can be no doubt in this case that the petitioner has indulged in certain activities which were not strictly in terms of the banking regulations and norms. And to that extent, it cannot be said that he was not guilty of any misconduct. However, at the same time, this court cannot also lose sight of the fact that the petitioner has not denied any of the allegations brought against him, but has explained his conduct by trying to justify the same in the manner indicated above. Full stop. The petitioner could be wrong in his understanding, but there was no intent on his part. But the fact that there was no intent on his part to embezzle any fund of the bank or to cause loss and injury to the bank is also apparent from the materials available on record. Viewed from that perspective, although this court is of the opinion that the petitioner cannot be given a clean sheet, yet having regard to the facts and circumstances of the case, this court finds force in the submission of Mr. Borthakur that the penalty of compulsory retirement imposed upon the petitioner by the impugned order dated 21/4/2011 is shockingly disproportionate to the gravity of misconduct as alleged against him. In view of the above, the order dated so-and-so stands interfered with. Notwithstanding the same, it will be open for the respondents to issue and to impose any other penalty upon the petitioner less than the penalty of compulsory retirement. Full stop. Since the petitioner has already attained the age of superannuation, the question of directing his reinstatement in service does not arise at this stage. Full stop. However, the order as provided by this court be passed within a period of 3 months from the date of receipt of certified copy of this order. Full stop. Depending on the penalty that may be imposed upon the petitioner in terms of this court's order, his pensionary benefits be revised stroke recalculated accordingly, and amount, if any, found to be due and payable to the petitioner be released within a further period of 3 months. With the above observation, this writ petition stands disposed of. What is the IA?
IA was for early hearing.
And we'll hear the IA next week. No, early hearing IA disposed of.
Your lordship, that in regard to the pensionary benefit, they have to follow to file their applications and. all.
That you handle. We are not saying anything.
Yes, sir.
He does not stand reinstated. He is not exonerated.
Yes, your lordship.
Only thing is compulsory retirement.
Only the less than compulsory.
Does
retirement.
less than compulsory impose any punishment.
Yes, your lordship.
That's all.
Biplab.
What is this? What appears for the petitioner? Matter stands adjourned for 4 weeks. Yes. These are all hearing matters. Is it a good time to start a hearing? What is this matter, Mr. Roy?
My lord, the order passed by the labor court is put to challenge. It will take some time, obviously. The site is also not here.
All right. And we'll do some other day.
Lots.
This, you are there?
Also, yes, my lord, take some time but the person is going to retire. It's for promotional learning. It's what that can be given, my.
Your matter is which matter? You are in the same
25,
case.
no, my lord, 25.
Oh,
I can
then
tell you. He's
it's
22.
after 4 weeks. Okay. Yours is 25.
25, yes.
Least after 2 weeks.
Can be, that can be given. by the
After
person
2 weeks,
going to
after 2 weeks.
receive
After 2
6
weeks.
months.
Yes,
2
after
weeks.
2
6
weeks.
months.
My lord, departmental proceeding. Criminal case, I was acquitted. The documents are before your lordship. It was said that I was a police official selling brown color substance. Subsequently, it came out in the criminal case. My lord, the substance that was seized and purportedly sent to the, my lord, FSL was not the one seized from me. So, my lord.
2 weeks, 2 weeks.
2 weeks, man. Much appreciated.
After 2 weeks.
2
After
weeks,
2 weeks.
after 2 weeks.
After 2 weeks.
Lordship.
2 weeks, 4 weeks, 3 weeks, whatever you do. Yes.